Well, good morning. I want to welcome everyone here to the Mississippi State Board of Nursing hearings. We like to start our time together with a moment of silence, prayer, and I'll ask Miss Nancy Norris Johnson if she would lead us.
Lord, we thank you, God, for this day. We thank you for all your goodness and your mercy, God. We ask you, God, to be with us today in Jesus' name.
Thank you. So we're ready to go on the record. I want to make some introductions. Just some background information first. The board is made up of 13 members. There's 7 RN members, 4 LPNs, 1 physician, and 1 consumer. Today, we are a 3-member panel of the board. We will have 1 alternate on the board who will not participate in either the deliberations or the decision concerning the case. And I want to introduce the board members because we do have more than 3, as you can see. We have some new board members who are here observing today. So to my far left, we have Jamie Clanton. She's an RN member. Lacey Gentry, also an RN member. I'm Mary Stewart. I'm an RN member. Sandra Culpepper, LPN. Jeremy Cummins, LPN. And Miss Nancy Norris Johnson, LPN. And we didn't divide RN and LPN intentionally, I don't think, but we really do all get along. So, to my right, I want to introduce the Honorable Edward Wiggins Jr. He is the Special Assistant to the Attorney General, and he will serve as the hearing officer today. For the panels today, Ms. Culpepper, Ms. Nancy Norris Johnson, and I will serve as the panel members with Ms. Lacey Gentry serving as the alternates. And before I forget, those of you that are online, if you would keep your mics muted unless you're asked to speak. And check my notes. That's it. Great. Mr. Wiggins.
All right, thank you very much. Good morning, everyone. As she stated, my name is Edward Wiggins Jr. I'm the Special Assistant Attorney General, and I will be serving as a hearing officer this morning. I will give the groundwork for how this proceeding will go forward. We will begin with opening statements. The matter before the board is license number P337419, which is a petition to remove stipulations. Because of that, we will begin with the case from the petitioner. If there are any witnesses, we will allow for witnesses to be examined, cross-examined, and redirect if necessary. The board member panel, as well as myself, will be entitled to question any witnesses that are presented. Once the presentation of both sides has concluded, we'll allow for closing statements. The board will then make findings of fact and conclusions of law and will render a decision in the matter, a copy of which will be sent to the applicant. At this time, I will ask that any witnesses be sworn in.
Mr. Franks, will you raise your right hand? You solemnly swear that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, ma'am. Thank you very much. Just for the record, I'd like to announce that a quorum is present. These hearings are open to the public. The board may deliberate and make its decision in executive session. Are there any preliminary matters, counsel?
Yes, there are some preliminary matters. Prior to admitting the exhibits, I want to draw attention to marked exhibit B15. Council and I visited about this exhibit, and I want to be sure, pardon, that the board does not consider on the marked exhibit the attendance for AA meetings that are listed here on that marked exhibit B15. Mr. Franks was not subject to that requirement. So council and I have conferred with that, and I just want to bring out that that component should be redacted. Issue with that.
No, I'm in agreement. Thank you.
So the attendance component is redacted from exhibit.
That's correct on B15.
Okay, thank you.
Just as, I'm sorry, just as a follow-up,
We just noted that it said no attendance at self-help meetings, and we didn't want that to be termed a negative for Mr. Franks because he was not required pursuant to his order to attend the self-help meeting. So we didn't want that to be confused.
Thank you for the clarification.
That, Mr. Wiggins, that the state would offer exhibits B1 through B15 to be admitted into evidence, as well as exhibits from the petitioner R1 through R3, that they as well be admitted into evidence.
Any objections to those?
We have no objection.
All right, thank you, counsel. Those are admitted. There is nothing further. We will begin with opening statements. Counsel.
Thank you, Mr. Wiggins. If it please the board, may I speak from my seat, or would you prefer that I stand or see a podium? So,
However you feel comfortable.
okay, if it's okay, I'll speak from here for distance purposes. Good morning. My name is Lisa McKay. I am an attorney here in the Jackson area. I represent Mr. Robert Franks, who is an LPN, who, as has been stated, is here today before the board with a petition to remove the stipulations on his LPN license and restore him to full status with no probation or stipulations on his license. Mr. Franks went to LPN school, successfully graduated, and then applied for his LPN license in October of 2017. That license was administratively denied at that time due to a criminal history that dated back to his younger days. He had several instances of some criminal misdemeanor activity from back when he was in college and young. He applied, of course, to be an LPN. The board felt that he needed to have some stipulations put on his LPN license initially, just because of the criminal history, to make sure things were straight now, everything was good moving forward. The board entered an order pursuant to a hearing where Mr. Franks was in attendance October the 30th of 2019, so almost exactly 2 years ago. Mr. Franks was required as a part of that order to have an evaluation. It was a biopsychosocial assessment at Turning Point Counseling Center. He successfully completed that assessment, and it was determined that he was at a very low probability of any substance use disorder. So that issue was put to rest, and I believe that kind of plays into why he was not required to do the AA meetings and that type of self-help meetings as a part of the board order. So this was really just to make sure that he had a good track record in his first couple of years as an LPN. The order itself allowed him to come back to the board after 12 months of successful completion of the order to request the stipulations be removed. And at the 12-month point period, he did apply to have the stipulations removed, but unfortunately, because of COVID, it has now actually been an additional period of time before we could get to a hearing today, and we're so thankful to be here today. But my point of that simply is he has now even had almost the full 2 years to continue with the requirements, which did include drug and alcohol testing and working with employers, giving reporting on him, that type of thing. He served as an LPN at the Blake, and he is still working on a PRN basis, although I think pretty frequently at the Blake as well. The exhibits that Ms. Thompson may reference that we have offered, and I have a couple of extra copies if anybody can't put their hands right on them, are 3 letters of recommendation for him for people that have served as his supervisors during this period of time. The first, which is R1, is a letter from Morgan Walter, who was his supervisor at the Blake. Also a letter from Anita Kipping, who's just a nurse who's very familiar with him personally and with his work. I believe she's been nursing for about 20 years, and she offered her personal recommendation of him. That's R2. And also Exhibit R3 is a letter from Ryan Fulcher, who is now the DON at the Pinnacle of Oxford, but also was one of the supervisors at the Blake. And he also spoke to Mr. Franks' qualifications, his work as a nurse, and also gave a personal recommendation for him. So those are our exhibits. I will be calling Mr. Franks just to answer a few questions and see if the board has any questions of him, but we would just offer that Mr. Franks has really done a good job of complying with exactly what the board asked for him to do almost 2 years ago. And we just come today asking for the board to consider removing those stipulations from his license so he can go forward as an LP.
Thank you, Ms. McKay. Councilman May.
We are here today on the petition of Mr. Robert Franks. Mr. Franks, as Attorney McKay did aptly state, is here today because the order that was entered by the board October 30th, 2019 did not allow for automatic termination of probation. So Mr. Franks is here today petitioning, requesting that the board remove stipulations. I would offer that in that order, October 30, 2019, Mr. Franks does carry the burden today to show the panel why he should have his license restored in full. The evidence today before you in testimony, if it's determined that Mr. Franks indeed has met all stipulations pursuant to the order, certainly the state would join Mr. Franks in requesting that the panel restore him. Thank you.
Thank you, counsel. Ms. McKay, you may begin with the case in chief.
Thank you. I'd like to call Robert Franks as our witness in this case. It's all right for Mr. Franks to testify from here as well.
Certainly.
Thank you. Mr. Franks, please state your full name.
Robert Anthony Franks
And Mr. Franks, where do you live?
in Oxford, Mississippi,
All right. And how long have you been living in Oxford?
since 2004.
Okay. And are you currently employed as a nurse?
Yes, ma'am.
Okay. Where do you work?
I'm PRN at the Blake at Oxford.
Okay. And also, do you have any additional jobs, nursing or non-nursing jobs?
I do too.
Okay. Tell me about those.
I'm a server and bartender at Bourré in Oxford, and I'm also a server at McEwen's of Oxford.
All right. And Mr. Franks, as a part of your petition today, I would like for you to talk with us about how the things that you've done over the last approximately 2 years since the order was entered by the board in October of 2019 to comply with this order. One of those things that you were asked to do, and I wanted to cover it first because it's a good bit of material, is you were asked to call in for drug and alcohol screens. And could you tell the board what you were required to do in that regard?
Well, there's an app on my phone, and I check in on a daily basis, and that would tell me whether or not I was selected that day to go in for a drug screen.
And do you know approximately how many times over this last 2 years you were selected to go in?
It's been 22 months. There were a few times it was twice a month, so I'm estimating over 30.
Okay, over 30 times that you actually had to test.
Yes, ma'am.
Okay. And then certainly it was every day that you could have had to test, and it was just up to the app to tell you whether that was
Yes,
the
ma'am.
day. Okay. And I have reviewed the Spectrum report, which is the report that sets out all of the results of your both calling in and of your actual testing. And if you had an opportunity to look over that as well.
Yes, ma'am.
Okay. And I noticed in all of these times that you've tested, there were only 2 times that it was anything other than just a straight out negative test result. Is that your recollection?
Yes, ma'am. Referring to the day I missed a check-in.
Okay, the first one that I noticed was in December of last year, and it says value was out of range. And you and I had talked about ultimately the board had a Dr. Barry Lubin look at that and call you and talk to you.
Yes,
If you
ma'am.
could just tell the board about that.
So the review officer gave me a phone call to talk about the result of that, and he told me that my creatinine levels were too high, which kind of threw me off, that it wasn't a dilute sample. But when we talked about it, he asked me if maybe I had been dehydrated and to make sure that I drink plenty of fluids and use the restroom a couple of times before I go in to give a urine sample.
And did that value out of range, did that ever happen any other time, or was it just that one time?
No, ma'am.
And then the only other time in all of these testing times that I noted anything other than just a negative result was on March 12th of 2021, which was March of this year. There was a positive drug screen on that, and I believe was for alcohol. Could you explain to the board what happened with that?
I do regret that. I had a lapse in judgment and went out with a friend of mine at work to celebrate a birthday, and I had drinks that night, and I was selected the next day for a urine sample, and I tested positive for alcohol.
And you regret that was a lapse in your judgment that you did.
Yes, ma'am.
But if I recall correctly, you had actually the reason that you were on probation was not an addiction issue. And in fact, Turning Point had determined that that was not a problem for you. Is that correct?
Correct.
And that again was something, that positive result, that had never happened before in all those months, and it had never happened since. Is that correct?
Correct.
Oh, and I believe you said there was one time that you missed a check-in, and that was resolved between you and your compliance officer.
Yes, ma'am. And I really don't have an excuse for that. I didn't check in when I woke up that morning. It was a busy day that day. I was delivering labs to the hospital, but like I said, not to make an excuse for it. I could have checked in when I woke up that morning.
All right, and other than those instances, all of these, I believe you said 22 months of checking in every morning and testing probably at least 30 times. You were doing exactly what you were supposed to be doing and have a good track record.
Yes, ma'am.
And I believe you said right now you're working PRN at the break. Is that correct?
Yes, ma'am.
Okay. Who is your supervisor?
Morgan Walter.
Okay, and she's one of the ladies, I believe, that has provided an affidavit or a
Yeah,
letter in
yes,
your
ma'am.
support of you. And we've asked the board to consider that as well as current status of his nursing. And as I believe we had talked about, your compliance officer during this last 22 months has been Ms. Natil Duncan. Is that correct?
Natil Duncan, and there was a lady, Miss Gigi, that was originally my compliance officer, but there was a while that I wasn't able to get in touch with her, and then I was informed that my officer had changed to Miss Natil Duncan.
Okay. And I do remember that. Thank you. And you worked with Miss Gigi and with Miss Natil on all of the requirements of your order. And to your knowledge, have all the requirements been met, and you have done everything you can do to the best of your ability to meet the requirements of the board?
Yes, ma'am.
And could you just tell the board just briefly why you're here today and what you would like for the board to consider doing as a result of this hearing?
I am here to petition the removal of my stipulations after being monitored for 22 months. I learned a lot working full-time in long-term care over 14 months. It wasn't as easy as I thought, especially with starting as a new nurse in the middle of a pandemic, but I fell in love with my clients and made a lot of good friends, and I would like to continue working as a nurse without stipulations. And I am looking to do travel work as well, but right now I'm required to work in Mississippi.
Okay, thank you.
Thank you.
I believe that's all the questions that I have at this time. I'll attend to the witness. Thank you.
Good morning, Mr. Franks.
Good morning.
How are you today?
I'm good, thank you.
Oh, for the record too, I want to make sure we have your address of record. Would you mind stating your current mailing address?
It's 1802 West Jackson Avenue, Oxford, Mississippi.
Thank you. So I'm going to direct you first to Exhibit B9. B9 is your final order that was executed October 30, 2019, issued by this board. Is that correct?
Yes, ma'am.
Okay, and that order was a result of you coming before the panel, having appealed your administrative denial that originally denied you an LPN license, right?
Yes, ma'am.
Okay, so you had a hearing June 6, 2019, is that correct?
Yes, ma'am.
Okay, and in that hearing, the panel did determine that you should be able to proceed with your application with some stipulations. Would you agree with me?
Yes, ma'am.
Okay, and in the findings of that order, I'm looking, Mr. Franks, specifically on page 2 of 7 of Exhibit B9. You would agree with me there that in those findings of fact that you were originally denied due to some extensive criminal history from a period of about 2005 to 2016. Would that be accurate?
Yes, ma'am. And I will say, before I was denied my license, I was offered an opportunity to enroll into the monitoring program, which I denied. Then my license was denied and I appealed that.
Okay. So when you came before the panel and certainly those criminal charges were discussed and issued, there was additional evidence that you submitted from a July 31, 2018 biopsychological, psychosocial assessment. Would you agree with me?
Yes, ma'am.
Okay, and you received that from a board-approved center, Turning Point Counseling and Consulting. Would you agree?
Yes, ma'am.
Okay, and in the order captured in the findings of fact, the board did find that those results did conclude you had a low probability of a substance use disorder, right?
Yes, ma'am.
Okay, let's look then in the same document here, Exhibit B9. Yes, and let's look at page 3 of 7. So the board then decided to provide you with the opportunity to practice as an LPN. Is that correct?
Yes, ma'am.
All right. And some of the things that you were to do specifically in paragraph 5 was you had to complete and provide successful completion of a substance use disorder course, correct?
Oh, yes, ma'am.
And you did do that, correct?
Yes, ma'am.
Okay. And then, on page 4 of 7 of that order, it also required you to present employer notifications and submit to drug screening. Would you agree?
Yes, ma'am.
Okay. Is it your testimony that you have provided to the board all employee reports and notifications that were required of you?
Yes, ma'am.
And in fact, those reports are captured in the evidence before the panel today. Would you agree?
Yes, ma'am.
Okay. Page 5 of 7 asks that you certainly submit to demand drug screens, copies of prescriptions. Did you have any? But you never had or was prescribed any controlled substance during this time, have you?
No, ma'am.
And in fact, that's also evidenced by Exhibit B14, which does show that at this time you have no prescriptive history.
Oh, yes, ma'am.
Okay, all right. And lastly, that you, within the order, beyond drug screening, beyond the class, that you would be required to be under this probationary time for a period of 12 months, correct?
Yes, ma'am.
But it's actually been a little longer than 12 months, right?
Yes, ma'am.
It's been about 22,
Yes, ma'am.
close to 2 years. Okay, and your order did state that you did not have an automatic termination of your probation, right?
That's correct.
So that's why you're here today.
Yes, ma'am.
Okay. Now, you testified earlier, Mr. Franks, when we talked about the spectrum drug screening from Exhibit B15, that you did have one positive, one value out of range, and one particular time where you did not call in and miss a test. Is that correct?
Yes, ma'am.
Okay. You did provide explanation. However, I do want to follow up and make sure with that positive screen, I believe it was March 12, 2021.
Yes, ma'am.
Okay, and that's actually evidence for the panel's review with that actual result. It's going to be page 40 of 110 if you're looking at B15. Mr. Franks, you acknowledged that you should have tested positive for alcohol on that day because you did have drinks the night before with friends, right?
Oh, yes, ma'am.
Okay. But it's not your testimony, or is it your testimony that you drink alcohol regularly?
No, ma'am.
Okay, and since the time you had engaged with Spectrum and with this board and monitoring, you have checked in, I believe this report says 597 times.
Yes,
That be
ma'am.
accurate?
Yes, ma'am.
Become a habit, would you say?
Yeah.
Yeah, okay. And again, because you did not have a positive assessment result, you were not required pursuant to the order to attend an AA or NA meeting, right?
No, ma'am.
Okay, now, certainly, Mr. Franks, you would understand that it might raise an eyebrow for the board panel to look that if they've given you an opportunity to practice, you have one alcohol positive screen, that might raise an eyebrow as to some noncompliance.
Yeah.
How, or what would you say to that would convince them that you should still be deserving of having a free clear license?
Like I said, I do regret that decision. And it was a lapse in my judgment. But I've never let the times that I do go out on instances like that, it's never affected my professional life or my work ethic or anything at work. And I am sorry about that decision, especially being on the monitoring program.
And Mr. Franks, technically, you would have been eligible to come before the panel in 2020, late October, November, something like that, requesting that you be removed, right?
Yes, ma'am.
But due to COVID and other issues, you are just now here today, making you 22 months in with your compliance,
Yes,
right?
ma'am.
Okay. Exhibit B11, Mr. Franks, would you agree? Again, those are your employer reports that have been submitted on your behalf from the Blake.
Yes. Yes, ma'am.
Okay, and it's your testimony that you've maintained employment with the Blake since being under the order from the board. Is that correct?
Yes,
Okay, and in fact, when you started, you weren't a full-time employee and they offered you full-time employment. Is that correct?
that's correct.
Okay, all right. And is it your testimony today that you will maintain employment with the Blake, or do you have other ideas should the board decide to lift the restrictions?
I do plan on remaining as a PRN employee at the Blake, which is actually now the Magnolia at Oxford, but yes, ma'am.
And lastly, Mr. Franks, you do understand pursuant to the order Exhibit B9, particularly in on the last page there, where it talks about it is further ordered. You do understand that you do carry the burden today to show to this panel, to the satisfaction of the panel actually, that you have satisfactorily complied with all conditions of your order. Do you agree with me on that?
I do.
Okay, and that further, you also are held to the standard of making sure they feel that you're capable of conducting yourself in a fit and competent manner.
Yes, ma'am.
Okay, all right. Nothing further.
Any questions for this witness from the board panel?
We'll probably cover some of the same things. So, Mr. Franks, first, thanks for coming today. It's always good to hear and to be in person to
Yes,
hear
ma'am.
your story. So I just have a couple of things. And maybe I should know this, but tell me what kind of facility the Blake or the Magnolia is.
So the Magnolia, it's an assisted living and memory care. I originally started working on the assisted living, but then took a full-time position in the Alzheimer's dementia, the memory care side.
Okay, so are you full-time or PRN now?
I'm PRN.
Okay, so you're not full-time.
I was full-time until July. For a full 14 months, I was full-time, and then accepted a bartending position at Bouret for monetary reasons.
Right, yeah. So, and that leads me to my other question. So, you indicated that the March 2021 positive result followed, went out, I'm not trying to put words in your mouth, just tell me if I'm wrong. You went out with some friends to celebrate a birthday
Yes,
from work.
ma'am.
So these are people that you work with at the bar?
Yes, ma'am.
Okay, so, a couple of things about that. Did you go into work with patients that same day?
Of
The day that you tested positive? I mean, you didn't know you
Yes,
tested
ma'am.
positive.
I did work that day.
Okay,
And I will say, and not to make excuses of anything, but the ethyl alcohol levels in my urine were 0. It was the metabolites of the alcohol that I tested positive for, and not to make an excuse
right.
at all, but I just didn't want to think that I was so overdone that I was hungover or anything like that at work.
Okay, so just to be clear, so you went out drinking, you tested positive, and then you went to work.
Yes, ma'am.
So, and then the other thing, just to clarify, because I think the question that Ms. Thompson may ask, what's your employment plans?
Yes, ma'am.
And you said, at one point, you said something about travel nursing. And then you said you
Eventually,
wanted to stay PRN, so,
I currently would like to stay PRN and look into the option of taking travel assignments. But I also, before I have taken into consideration before traveling, doing a bridge program from LPN to RN. So I would like to continue my education, possibly BSN, before I really dove into travel work. But my options are open right now. But for the time being, I would stay PRN at the Blake.
and you intend to stay, are you full-time or part-time bartending?
Full-time
And you intend to stay in that position as well?
for the time being.
Okay.
Yes, ma'am.
All right, and just, and I realize that we're not here to make a decision about your history of criminal behavior, but that was a span of 2005 to 2016,
Yes, ma'am.
so about 11 years.
Yes, ma'am.
And can you just help? I wasn't on this panel, so I'm trying to get some context. It says it included alcohol and drug-related offenses,
DUIs.
multiple.
Yes, ma'am. There was, I believe it was 2005, 2010, 2015.
Okay, all right, thank you. I don't have any.
Yes, ma'am. Thank you.
For me, Mr. Franks, I have a few questions.
Yes, ma'am.
How often currently do you work PRN?
Since July, a couple of times a month.
A couple times a week, 2, 3?
Yes, ma'am, too.
So just 2 days out of the month, correct?
Yes, ma'am.
PRN? And to clarify, once again, you're seeking to perhaps go to travel nursing. And in regards to that, do you believe it would benefit you? Because you're relatively still a new nurse.
Yes, ma'am.
Would it benefit you to work full-time in your home state before you proceed to travel?
I do. I do.
And I think one of the other things I need to point out for me also is, since going under the board's order, have you had any incidences in which law enforcement was involved?
No, ma'am.
and I believe the last question, it kind of follows up on Dr. Stewart's. Do you believe there's any correlation to you remaining as a bartender in your previous history? And how will it impact your nursing career?
I do not think that that has a correlation because those were different circumstances and I was working different jobs when I did get those DUIs. One of them, I was working at Home Depot. I don't think that there's a direct correlation between my criminal history and working as a bartender. No, ma'am.
Mr. Frankston?
Thank you so much.
Any further questions from the board panel?
Frank, you worked over a year full-time,
Yes, ma'am. 14 months.
PRN.
Yes, ma'am. Yes, ma'am.
Anything further from the panel? Any redirect, Ms. McKay?
If I may have just a second with my client. I would like to clarify something for the panel, if I may.
You may.
Mr. Franks, there was a question asked about, older Jane, she had positive drug screen, and it was asked, did you then test positive and then go into work? And I believe you said yes. But Mr. Franks, did you actually have that test result before you went into work?
No, ma'am. It was about a week later when I received the result of that that urine sample.
Right. And I believe what you testified to earlier is it was metabolites that showed up, and it was not that you were feeling any effect from that when you went into work that day.
Correct.
I think that's all.
Okay, so, and I understood that, I realized that this a week later, but feeling an effect, I mean, that's the issue, obviously, with substance use, is you can't judge that for yourself.
Yes, ma'am.
That's the concern. And so you were at a level, regardless if it's metabolites or whatever, you were at a level that tested positive. And you couldn't discern that you had that level, you went into work. So that's what I was trying to
I
clarify.
understand.
Instead of saying, I went out last night, I probably don't need to go to work today. That.
I understand.
Okay.
Yes, ma'am.
Okay, that's a good. Okay. So, that's something I wanted to ask too, that can you just talk us through that timeline? Like if you close the bar, tell me what happened.
It's been a while, but around 7 or 8 o'clock, we went out and had a few drinks, but I was at home and in bed at my normal hour. I usually go to bed at around 10 or 11.
And you went to work at what time?
7:30. Our shifts changed from 8 hours to 12-hour shifts, and that was before we made that change. So it was 7:30.
AM.
Yes, ma'am.
That's helpful. Thank you.
Thank you.
Anything further from the panel? Ms. McKay, any redirect after that? Ms. May, did you have anything further?
Do not.
Ms. May, does the state have a case it wants to present in this matter?
Do you all want closing arguments at this point? Because the state would rest from.
Okay. You can certainly begin with closing.
Thank you, Mr. Wiggins. Ladies and gentlemen of the panel, I will be brief. Mr. Franks today has, I believe, met his burden of showing that he has been cooperative and compliant with the order that the panel, that the board put in front of him almost 2 years ago. It's regrettable that there's even one mark on that spectrum report, because as the panel knows, it's about this thick. He checked in over 500 times. He was tested well over 30 times. And again, his history in terms of the evaluation at Turning Point that the board had him undergo showed that, based on their evaluation, that he was at a very low possibility for any type of substance use disorder. Mr. Franks has been, I think, very forthcoming, and was very forthcoming a couple of years ago about he made some bad decisions in his past. He had a criminal history. He has not had any criminal issues at all during the entirety of the time that he's been under the board's order. I would hate to see one moment of going out to celebrate a friend's birthday to completely derail what I think is based on what I'm seeing from these letters of reference, a promising nursing career. I wanted to actually look back and make sure I was remembering correctly that one of these letters from his supervisor at Blake, Ms. Walter, talks about how he was just doing a wonderful job for them during the height of the pandemic, which, as these ladies and gentlemen know, is a very difficult time for all medical workers, and it's very difficult to get nurses willing to come in and do the job that needed to be done. And Mr. Franks did that, and did it well, and did it willingly. And I think these 3 letters of support, the people that were right there with him, working with him daily, really say more than I could ever say. So I would ask the ladies and gentlemen of the panel to please consider Mr. Frank's petition to have these stipulations removed, and please give him a chance to move forward in his profession. I think that he has shown great remorse for the indiscretion he had on that one testing, and certainly is wanting to go forward and just do the very best he can for this profession. And I would appreciate the board's consideration.
Thank you, Ms. McKay. I'm sorry, Ms. May.
For the panel today, you do have a petition requesting that this panel remove the stipulations of Mr. Robert Franks. You've heard testimony. You will weigh evidence as you deliberate. The facts present themselves that Mr. Franks actually has had a continuum with this board. In 2017, applying for his LPN license to be denied, he did petition or appeal that particular decision, came before the panel. The panel looked at all of the criminal offenses from the 2005 to 2016 timeframe, and determined at that time, given the assessment, that indeed Mr. Franks did deserve an opportunity to practice as a nurse. So the panel overturned the denial and allowed him the opportunity. In the order of October 2019, the panel decided to provide Mr. Franks that opportunity and placed him on 12 months of probation. It's now been since 22 months, give or take, almost 2 years since he was under the board order. Certainly within that order, again, what the panel should be called attention to is the fact that it's not an automatic termination. He's here today requesting the panel review and consider removing those stipulations, but he also is here with the burden to show to the satisfaction of the panel that he's done that. So within that testimony and in that evidence that's provided you today, certainly an eyebrow would be raised as to the positive screen. Certainly. He has provided explanation to that. It's now up to you to determine whether or not that in a vacuum is enough, that it doesn't satisfy the burden, or that he has collectively met the conditions that the board has outlined, and that he would deserve a chance to have a free and clear license. Understand your job is to protect the public, and you should weigh testimony and evidence, not only to that effect, but in the effect of the burden that Mr. Franks carries. Thank you.
Thank you, counsel. Having heard the testimony regarding license number P 337 419, will now entertain a motion for the board to enter closed determination to ascertain whether executive session is required.
I move that the panel go into closed determination to assess the need for executive session to consider the case of Mr. Robert Franks.
Been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? The motion carries. I will now entertain a motion for the board to enter executive session for deliberation on license number P 337 419.
I move that the panel go into executive session to deliberate the case of Mr. Robert Franks, P 337 419.
And I will second that motion.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Thank you. The board will now exit to executive session. You may remain here, and we will return with a decision regarding this matter. Thank you.
Thank you.
Hello, Mr. Warsh, how are you?
I'm doing well.
Fantastic. The board is in deliberation right now on the first case. So you feel free to mute your phone, your Zoom and or camera, but they will return shortly.
Okay, so I should mute the camera and the,
The attorney just walked in, so she knows that you're on the Zoom now.
Is that Mr. Wash?
yes, this is Al.
Hi.
Hi.
Yes.
Great idea to form a-
All right, thank you everyone for your patience. We will go back on the record. At this time, I will entertain a motion for the board to return to regular session.
I move that the panel return to regular session.
I will second.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. The board panel is now back in regular session. Once again, thank you all for your patience. We do take these matters seriously. Following deliberation on license number P 337-419, P 337-419, the board panel renders the following. The probation term is denied. There will be an additional 12 months to include indirect supervision, completion of an ethics course, drug screens, minimum work of 60 hours over a 2-week period. Failure to comply shall result in a show cause hearing. A petition for a term of probation to be released shall be required. A copy of this order will be forwarded to the licensee and his attorney within 2 to 4 weeks. Are there any questions, council? Hearing none, you're excused for this matter. Thank you. Good morning. The next matter before the board panel license number R726591, R901634. Is the licensee present?
Yes, sir.
At this time, I would like to have all witnesses sworn in.
I would ask for all witnesses to please raise your right hand. Do each and every one of you solemnly swear or affirm that you will testify. Sorry, I just lost my train of thought. Do each and every one of you solemnly swear or affirm that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth, so help you God? I'm sorry.
I do.
Okay, thank you. Mr. Warsh,
It's on mute.
you're muted, Mr. Warsh.
I do.
Right before we get started, I kind of like to lay out some groundwork for us this morning. We will have opening statements. This matter is a show cause hearing. Any witnesses will be, of course, examined. There will be opportunity for cross-examination. Questions from the board panel will be allowed. At the conclusion of the presentation of both sides, we'll have closing statements. The board panel will make findings of fact and conclusion of law and will render its decision. Since we've had the witnesses sworn in, I will note for the record that a quorum is present. Also note that these hearings are open to the public. The board may deliberate and make its decision in executive session. Do we have any preliminary matters, council?
Yes, at this time, the state would prefer and ask that exhibits B1 through B16 be admitted into the record as evidence. And Mr. Orel has additionally submitted exhibits with an evidence list, I believe, A through G. That's also accompanying the state's exhibit, and the state would move that both sets of these exhibits be admitted into the record.
Do you have any objection?
No, sir.
They will be admitted. Mr. Orel, you're not represented by counsel. You understand you have the right to be represented by counsel?
Yes, sir.
You understand you have the right to examine witnesses?
Yes, sir.
You also understand that you have to have the right to have subpoenas issued on your behalf by this board.
Yes, sir.
Although you are without counsel, you are ready to proceed with this matter.
Yes, sir.
Thank you. We can begin now with opening statements.
Yes. We are here today in the matter of Christopher Orel, license number R7266591 and R9016634 CRNA. This is a MNVP show cause hearing. The state will allege today that Mr. Orel did sign voluntarily an agreement to enter into the Mississippi Nurse Voluntary Program on or about December 15, 2020. At some point, relatively shortly after he signed, Mr. Orel communicated via verbally and in writing that he wished not to continue with the program any longer. And so the state would ask and submit before the panel today that the evidence testimony would show that because Mr. Orel entered into the agreement voluntarily, he has violated a contractual obligation with this board, and the evidence testimony would show that Mr. Orel's voluntarily entering and then since rescinding would constitute a violation of the Nurse Practice Act.
Thank you, Council. Mr. Orel.
In May of this year, I was offered a job after 13 months of employment, to say the least, with the prospect of going back to work. I notified Ms. Loper about this and asked what would happen if I dropped out of the program. 3 days later, I sent her a notarized request to drop out. This was a rash decision, and I wasn't thinking rationally, but reacting emotionally. I regretted that decision soon after and asked to rescind my request to drop out. A few days later, I was notified by email that my participation in the program had been terminated and that it would be turned over to the Board of Nursing Legal Department. I stand here today before the board begging forgiveness for an emotionally charged decision. Re-enter the MNVP. I was compliant in the program up until the day I was terminated. I haven't used drugs or marijuana since January of 2020. I'm active in Alcoholics Anonymous, working weekly with my sponsor and attending at least 3 meetings per week. I haven't used alcohol since October 11th, 2020. I'm approaching 1 year sobriety. My sole interest is to return to the workforce. I obviously made a mistake driven by emotional thinking, by requesting to drop out of the MNVP. And I'm willing to do whatever it takes to clear up this matter and return to work. I've been a CRNA for over 32 years, and this is the only blip on my record. I never dreamed that my career would come to a screeching halt like it has. Again, I wish nothing more than to return to work, and if re-entering the MVP gets me there, I'll sign up today.
Counsel.
Yes, I call Casey Loper as the first witness, please. Ms. Loper, for the record, please state your name.
Casey Loper.
And in what capacity do you serve the Board of Nursing?
I'm the Mississippi Nurse Voluntary Program Manager.
And are you familiar with the case involving Christopher Orel?
I am.
Okay, and just from a general sense, can you tell the panel how you're familiar with this case?
So in October of 2020, Mr. Orel contacted me and self-reported that he had a substance use issue and that he was interested in entering the program.
Okay, and can you, before we get into semantics, can you just tell the board a little bit about the Mississippi Nurse Voluntary Program? What is it?
So we're an alternative to discipline program for nurses that have substance abuse and or mental health disorders. It is a way to support nurses in returning to the workforce safely in recovery and providing them support and monitoring throughout the life of their contract and after if they choose to reach out to us. So people can self-report to us at this time. We also accept reports from investigations for people who may not have been aware that this was an option for them when they reported. We were passed into law, Mississippi Admin Code 2826, July the 1st, 2019. And so we are a relatively new alternative to discipline program. But you know, our goal is to support nurses, keep them in the nursing force, but also protect the public at the same time.
And when you say the program is alternative to discipline, Ms. Loper, what does that mean?
It means instead of coming here for a board hearing, that they enter into an agreement voluntarily with stipulations in place outlined in their contract, and that they adhere to those. And then if there is a breach of contract, then we look at options that are available. So extending a contract, increasing drug testing, increasing meetings, we can do a variety of different things, having a reassessment, looking if treatment is needed again, or possibly for the first time, or possible termination from the program, just depending on what's going on. Some things are outlined by law that we have to do, and some things are kind of left up to our discretion.
So would it be accurate to say that the program affords a nurse the ability to be monitored, yet not receive discipline against their license while they
Correct.
participate?
Yes.
Okay. And would it also be accurate to say that the program itself is not mandatory?
Correct.
Okay. And in fact, what is the philosophy behind participating within the program?
We want nurses that have identified an issue, have identified that they need help and support to enter into the program. And we want to provide that to them. So that's why it is a voluntary program. So once offered the program, we determine if they're eligible for the program based on what the law outlines is eligible. Their agreements with entering into the program, which is outlined in the agreement as well, that it is voluntarily entered into. And we want to help nurses who want to receive help and services and support from us.
So given Mr. Orel, can you walk the panel through from the moment that you received the call where he self-reported, what were the steps that were taken with Mr. Orel that ultimately led to his signing the MMVP agreement?
So Mr. Orel called, and I gathered some information from him. At that point, an email was sent out with a pre-intake, what we call a pre-intake packet. It just is some things in writing, demographic information, what prompted them to report what was going on with them. At that point, once we receive that, we do require that an assessment from a board-approved assessor be done. In Mr. Orel's case, that had previously been done, and that was sent over to us. At that point, we were looking at his eligibility for the program because it was our understanding that there was an investigation that was open against Mr. Orel that was related to practicing without a license, which would have disqualified him from entering into our program. It is my understanding that was unsubstantiated. There was no license issues. And so that then made him eligible for the program. During that process, Mr. Orel reached out to me and said after about, I believe, 3 weeks of doing an outpatient program that he decided to enter into an inpatient program with Pine Grove. Entered into that inpatient program. We had several communications while he was in there. And then he completed that program. We received that information. We verbally, over the phone, went over the contract. And then he came in for an intake on December the 15th of 2020 to enter into that agreement.
Okay. I want to hand you now, Ms. Loper, Exhibit B8. For identification purposes and for the record, what is Exhibit B8?
Exhibit B8 is the page 3 of our MMVP pre-intake packet. It just is a narrative of them explaining why they felt that they were a good candidate for the program, what was going on, and what they want to receive.
Okay, and so can you testify as to whether or not the information contained on this pre-intake, is it from Mr. Orel?
This came via email from Mr. Orel, yes.
Okay, and in the contents of this statement, was there any admissions or any statements made related to Mr. Orel having struggled with a substance use or abuse type of disorder?
So Mr. Orel discloses in here that he did test positive at work on January 21st, 2020 for marijuana. And also, I believe, mentions substance use related to alcohol, drinking more and unable to sleep at night, and then using marijuana as a way to cope as well.
Okay, so this pre-intake information, Ms. Loper, this is used as well as part of the eligibility requirements prior to signing the MMVP agreement?
Yeah, so part of the requirements is that the person entering into the agreement admit that there is a substance abuse and or mental health issue that is in need of services or in need of support through the program.
You mentioned as well the eligibility requirement of obtaining and submitting to an assessment. And I believe your testimony was that Mr. Orel did go into treatment with Pine Grove, inpatient treatment with Pine Grove, and that ultimately released MMVP, the discharge summary of that stint. Would that be
Yes.
correct? Okay. And Exhibit B12, in fact, reflects that discharge summary. Would you agree with me there?
Yes, so this was not the initial assessment. The initial assessment was provided to us from Dr. Gatz. Mr. Orel then sought inpatient treatment, and then this was the discharge paperwork provided to us by Pine Grove,
Okay.
directly from Pine Grove.
Okay. And can you tell the panel what date that Mr. Orel entered into that treatment and then date that he was discharged from that treatment?
Mr. Orel entered into treatment on November the 2nd, 2020, and he was discharged from treatment on December 11th, 2020.
Second page of that discharge summary, Ms. Lakeworth, can you, again, for the record, testify as to what the discharge diagnosis was of Mr. Well, actually, the admission diagnosis of Mr. Orel and then the discharge diagnosis of Mr. Orel?
So at admission, Mr. Orel was diagnosed with alcohol use disorder, moderate, cannabis use disorder, mild to moderate, substance-induced mood disorder, moderate, and a history of major depressive disorder, recurrent, moderate. At discharge, his diagnosis were changed to alcohol use disorder severe in a controlled environment, cannabis use disorder moderate in a controlled environment, and major depressive disorder recurrent mild.
One minute. Page 9 within the Pine Grove discharge summary relates to return to work recommendations that Pine Grove imputed and provided Mr. Orel. Would you agree with me?
Yes.
Okay, and for the record, can you identify what Pine Grove has here in terms of their return to work recommendations for Mr. Orel?
So his return to work recommendations are outlined on number 2 of that, which is page 9, which is
1 and 2, right? The recommendations.
well, that I think 1 is not related to work. It's just related
Right.
to signing an agreement. And that agreement being a 5-year agreement that he be monitored for 5 years, including random drug screens.
And that number 1 is important because Pine Grove actually endorsed him entering into the nurse voluntary program for a period of 5 years. Is that true?
That is correct.
Okay, and that he could work if he signed under the agreement with certain recommendations. Would you agree?
Yes.
All right, and what were those work recommendations?
So those work recommendations are that he worked day shift only, no more than 84 hours biweekly for at least 1 year, that he refrained from working in high-risk areas such as ICU, CCU, ER, RR for at least 6 months, no employment in agency staffing, pool home health services, nursing home or travel nursing, that he work as a member of a team, that he work in a non-supervisory role, that he limit on-call time when possible, he obtain a workplace monitor who can report directly to MMVP, and that he obtain written approval from MMVP prior to changing any restrictions.
Ms. Looper, was any conversation had with regard to what Pine Grove had submitted? Was there any conversation that you had with Mr. Orel as to these work recommendations?
So those work recommendations are integrated into our agreement. Some of those are already a part of our agreement, and some of those are personalized. So our agreement does not outline how many hours somebody can work. So that would be outlined in his agreement based on the report that we received. We already don't allow work in home health, hospice, we do allow nursing homes or travel. So that's already outlined in there. We do personalize each agreement to what recommendations are from the assessor, as well as what is required by law.
Okay. And so Mr. Orel, pursuant to your conversation, understood this is what Pine Grove had recommended, and he was willing to do those things at the time that you communicated with him.
Yes.
Okay. All right. You mentioned a prior assessment, and that was from a Mr. Gatz. I believe that was roughly 7 months earlier, March of 2020. Does that sound about right?
Yes.
And again, this report outlines information, but ultimately, Mr. Orel did decide to do inpatient treatment with Pine Grove, right?
Correct.
Okay. All right. Okay. So let's now get to Ms. Loper, the agreement itself. So you walked the panel through the process of the voluntary program, correct?
Mm-hmm.
And you've explained to them the importance of the eligibility requirements, what Mr. Orel did to the point of getting him to the day that he was to sign the agreement. Do you agree?
Yes.
Okay, so let's talk now about the day he came to review and executed the agreement with the MMVP program. Tell the panel what happened.
So we went over the agreement in detail for what would have been the second time. The first time would have been over the phone. At one point, Mr. Orel, when he was going through the agreement, did ask to step out and reach out to a union rep, or asked to call a union rep, which he reached out to said that that person did not answer, likely because he was working and not able to answer union questions at that point. I stated to him that we could always reschedule if he wasn't comfortable signing, because we don't want anybody to sign an agreement that they're not comfortable with, which is why we review it prior to them coming in. And then also again, thoroughly when they do come in for intake. Mr. Orel asked at that point in time if he was able to withdraw from the program. We went over the terms of the agreement, which is, I believe, J in the agreement. It does have a statement, if I have voluntarily entered, if I have voluntarily entered MMVP, anonymous of the board and will remain anonymous as long as he's compliant with requirements, and that if he elects not to participate, withdraw without notice, or dismiss for noncompliance, he would be reported immediately to the Board of Nursing for further review. So we talked about that statement being in the agreement if he chose to withdraw from the program. Again, stressing that I wanted him to be comfortable prior to signing the agreement. And if he needed some time to stop and think about that we could do that.
And Ms. Sloper, when he came and did, the process of explaining the agreement, so you're saying you did detect hesitancy then from Mr. Orel?
Yes.
Okay, and you did offer him an opportunity to come back and think about the agreement?
Yes.
Okay, and not only, you mentioned paragraph J, but I wanted to bring to the board panel's attention, as well as paragraph P, as in Paul, which is on page 8. Would you agree that, or can you tell the panel what Mr. Orel's concerns, if any, did he have with disclosing this agreement with employers?
At that point, I don't recall him expressing any concern about disclosing to an employer. I do, if I remember correctly, remember hesitancy related to returning to work with a narcotics restriction.
So he had no problem giving this agreement to any employer?
Not that I remember being expressed to me.
Okay. And when you went over this agreement in its entirety, did he understand that he was voluntarily entering into a 60-month or 5-year contract?
Yes, that was discussed when we reviewed it prior to him coming in, and also then when he was in person signing the agreement.
Okay. And this entire agreement is 9 pages. Would you agree?
Yes.
Okay. And how long did it take you to go over each and every paragraph and explain the conditions?
For each person, it's different. Most of the time, it takes roughly about an hour to get through the agreement part, and then about 30 minutes to go through some other documentation that we provide them at intake. Their reports, their chain of custody, papers, just some other stuff. But typically the agreement itself takes typically about an hour.
Okay. And you mentioned in your testimony just now about the hesitancy with regard to signing the agreement about narcotic and distribution. And I believe paragraph H would speak to that. Would that be correct?
Yes. So H outlines closer to the end that he may not administer narcotics for a minimum of 6 months.
And is that his initials there agreeing to that paragraph?
It is.
Okay. So did you explain to him that during a 6-month period that he was prohibited from having access to controlled substances through his employer?
Yes.
Okay. And did he provide any response to that after you went over that in detail?
I think that is when he asked to speak to his union rep. If I recall correctly, that's when he asked to speak to the union rep. Obviously having a CRNA, that would be concerning. But we have other CRNAs in the program that have that same restriction in place, that just use their RN license.
Until that time is up?
Yes.
And that was explained to him as well?
Yes.
I want to also refer Ms. Lepper to the handbook and the rules. I believe Exhibit B10 and Exhibit B11, B10 being the MMBP Rules and Regulations, Part 2826, Exhibit B11, the MMBP Participant Handbook. Can you just briefly explain to the panel how the participant becomes aware of these items, and are they discussed in the participation of the program?
So typically I mention, when we're going over eligibility, that it is outlined in part 2826, Mississippi Admin Code 2826. We don't provide Admin Code 2826 to every participant, but they have the availability of it by going on our website, which we do let them know when they receive their packet of paperwork that they take with them. Our website is also written on their packet, just so that they have it easily accessible. They can also go to the Board of Nursing website, go down to Mississippi Nurse Voluntary Project Program, and click there to go to our website. So they are made aware that it is part of a law and that it is on our website, but we don't provide that to them necessarily unless we were asked. I think only one person that I can recall has ever asked to be provided that document, which we don't have a problem providing, but that was not the case then. B11 is our handbook. So we make participant for what we call potential participants. And until they sign an agreement, we do call them potential participants because they're not actually in the program. And
Sorry, the court reporter saying so.
oh, sorry. And so we let them know that the handbook is available on our website. Then when they come in for their intake and to sign the agreement, that they are provided a hard copy of that as well.
And Ms. Loper, I'm going to hand you the Exhibit B10, which is the law related to the Nurse Voluntary Program, Part 2826. The last page of that, the rules and regulations, Rule 1.12. For the record, can you please read Rule 1.12 and then subsection A for the record, please?
So Rule 1.12 is termination from the MMBP program. Participation in the MMB program may be terminated for any of the following reasons. A, outlines that the nurse applicant fails to comply with any of the terms and conditions of the program specified in this part.
And I want to go back to the agreement. Exhibit B9. And I want to go to specifically page 8, subsection Q. Specify to whether that same language that you just read, that's the law, part 2826, is it also not captured within the agreement with regard to program completion or termination?
So in Q, it's outlined as number 1, which is failure, or I fail to comply with any terms or conditions of the program and or the MMBP agreement.
Okay, and whose initials appear there beside the paragraph Q?
Mr. Orel.
And that was explained to him as well in terms of program completion?
Yes.
So Ms. Loper, we are now at the point that if Mr. Orel signed December 15, 2020, when is it that you first heard from Mr. Orel that he did not want to be in the program any longer?
Mr. Orel sent me an email that he was considering terminating his agreement due to not wanting to disclose to an employer, entertaining a job offer. And that email was May the 19th, 2021.
So roughly 5 months into the program, you learned he does not want to be in the program any longer.
That is what he said that he was looking at possibly withdrawing.
Okay, and so talk the board through that process and interchange between you and Mr. Orel about his request.
So I responded to Mr. Orel just to let him know that if he chose to terminate his agreement, that the information would be sent over to the legal department to determine if there would be further action. And that I have no way to determine what that action would be. He then responded that he was choosing to opt out of the program and asked if his email would suffice. That was on Friday, May the 21st. I let him know that that if he was choosing to opt out of the program, that he would need to provide a handwritten letter that was signed and notarized, and to send me the electronic version of the original in the mail. At that point, I also reminded him of his agreement of Part J, which I quoted the part that says if you elect not to participate in that statement, as well as Mississippi Admin Code 2826, Rule 1.12, that covers termination, that if they fail to comply with the terms of the agreement, that relates back to the terms that he signed for, since he would not be meeting the specified length of the agreement that he entered into for 60 months.
And what did you do with that written request once it was submitted to you?
So that email was sent to him on Friday, May the 21st. On May the 24th, he provided a electronic copy of his request to withdraw from the program. So we took that as his official notice of withdrawal. He then emailed to request on May 25th, so the next day, that he was having second thoughts about getting out of the program, and could we talk about modifying the part about narcotic access and distribution at work, that he was interviewing for a job and would like to be able to tell them that they would not have to babysit him if that's doable.
So let's stop there. So you receive, let's make sure we get this straight. You received 1 or 2 emails from Mr. Orel, where he stated he wanted out of the program.
Correct. I believe he mentioned that he was entertaining it in one, said that he did want to in another one, and asked if that would suffice. And then a third email providing the notarized signed copy of withdrawal.
And then how many days later, after the signed notarized statement, did he again reach out and say, wait a minute, I want to rescind that?
It was the next day that he reached out, that he asked about rescinding, and that he wanted to look at having his narcotics restriction lifted.
Okay.
Excuse me, what was the date of the notarized email?
The notarized email was May the 24th. The original email came in.
I have it here. Actually, to cure that, this is what I was looking for. Ms. Loper, for the record, I'm gonna hand you Exhibit B6. Can you identify B6, please?
B6 is this copy of the letter that Mr. Orel provided that is notarized, that he wanted to withdraw from the program.
Okay, and what is the date of that request?
May the 24th.
Okay. So let's back up. May 24th, he provided the formal request asking for termination of his agreement, correct?
Yes.
Okay, and then what are the dates prior to that with his request to make the agreement?
The original email was sent on Wednesday, May the 19th, that he was looking at entertaining a job offer and not sure that how he would tell them that he was in the program and how that would affect him, and what he asked what would happen if he left the program.
Okay.
I responded to him on May the 20th, that if he chose to terminate, that it would be sent over to legal, and that I had no way to determine what action would be decided. On May the 21st, he said that he was opting out of the program and that he would that email suffice. On May the 21st, I responded to him that it would need to be in writing. And then 3 days later, I believe, 21st, and so the 24th is when it was provided. So 3 days later is when he provided that written statement.
Okay.
The day after that is when he asked about rescinding that.
And that would be May 25th, 2021?
Correct.
Okay, and so when you were contacted about the possible rescission, tell the panel what happened after that.
I let Mr. Orel know that it would be brought up during our case review. So we have a internal case review for MMBP 2 times a week, where we discuss potential participants and our current participants and what's going on with them. That happens on Tuesdays and Fridays. He reached out, the 25th was a Tuesday. We had already done case review for that day, so it was going to be reviewed on Friday, and that I would let him know what decision had been made at that time. I had let him know on Friday that his decision to terminate from the program was accepted, and that we were not going to do the rescission of that request to terminate.
And Ms. Loper, I'm gonna hand you Exhibit B7. Can you, for the record, identify B7?
B7 is a certified mail that was sent out to Mr. Orel that outlined that on May 24th, he officially withdrew from the program. It outlined Part J and Mississippi Admin Code 2826 again, and just let it know that this was his formal notification of termination from the program.
So this was a letter of termination, correct?
Yes.
And it was sent on what day?
May the 28th.
Now, Ms. Loper, I know that he requested that he be reconsidered for the program. Can you just briefly explain that there is a difference between the voluntary nurse program and compliance in our board? Can you just briefly explain the difference in that?
So the alternative to discipline, the Mississippi Nurse Voluntary Program is an alternative to discipline. So there's no discipline that follows a nurse on their license. As with compliance, it can show discipline or current discipline or prior discipline on their license through the life of their nursing career. We have a little bit more involvement in what's going on with our participants than compliance does, in order to provide that support to our participants to make sure that if we notice something that's abnormal with them, that seems out of character for them, that we reach out and say, hey, this seems out of character, because what we know about addiction is that relapse happens prior to in our actions prior to use. And so we're just a little bit more hands-on, I think, than other departments are. And we're voluntary because we are an alternative to discipline program. So we're not forcing anybody into it. We don't want anybody in it who doesn't want to be in the program.
So he was not ordered to be in this program.
No.
So this was something that was his decision. Would you agree with that?
Yes.
Okay. And multiple times from the beginning, you even mentioned to him that he didn't have to go through this process.
Yes, he was provided the opportunity to ask questions during a phone call if he had any questions related to the agreement. When he came in and expressed some hesitation and request to call, I explained to him that we could reschedule that he could come back later that day, he could come back another day. But by no means was he going to be forced or expected to sign an agreement he wasn't comfortable with.
And when he did sign December 15, 2020, at that time, he did enter into a legal contract with the program, correct?
Correct.
And the conditions and stipulations that are contained in the agreement, he was bound to.
Correct. That's outlined in the monitoring agreement, letter A, said it's a binding agreement.
Okay. I'm going to hand you Exhibit B16, Ms. Lober. For identification purposes, can you identify B16?
B16 is a compliance report out of Spectrum. Spectrum is what we use to monitor our participants. It's where they check in, they provide documentation to us, we provide communication and things.
Okay. And so at what time did Mr. Orel begin compliance with Spectrum?
December the 15th, 2020, when he signed his agreement.
Okay. And is this report a general summary of his activity with Spectrum?
Yeah.
The record explain what you see here on this document as to his compliance or lack thereof?
So from the time that Mr. Orel entered into monitoring until the time that he was terminated from the program, he had one missed check-in. He had 7 drug tests and all 7 were negative. And he was compliant with his attendance reports.
Okay. And so he was in this Spectrum system, again, beginning December 15, 2020 until what time?
When the official termination notice was mailed out, which was on May 28th, 2021.
And those dates are reflected as the period of his compliance on Exhibit B16, are they not?
Yes.
Okay. One moment. Ms. Laber, can you speak to any other compliance issues before the panel beyond Mr. Orel not completing, obviously, the 60-term agreement, not checking in with Spectrum or submitting to drug screens? Are there any other compliance issues that need to be brought before the panel that have not already been addressed?
Not that I can recall. I mean, during the program, he was doing the things that he was supposed to do, which was why it was a little bit out of the blue that he requested to withdraw from the program. But given the hesitation initially, to sign the agreement and specifically asking about withdrawal from the program, we decided to accept it at that point because it did not feel like he wanted to be a part of that, of the monitoring program.
Attend to the witness.
Mr. Orel, do you have any questions for this witness?
Yes. Ms. Loper, has anybody ever rescinded a request to withdraw from the program?
No, other than you, no.
Would 3 days typically be enough time to honor that rescission if you were open-minded about it?
We were open-minded about it. When it was sent, it was not just me as your case manager that reviewed it. It was also our program director and another case manager. And so given the length of time that you had to think about it before providing a notarized letter, that was taken into consideration too, as well as the statement about wanting to reverse your narcotics restriction.
Okay, nothing further.
Any questions from the board panel for this witness?
Oh, I do have a quick question. Ms. Loper, so the phone conversation that you had prior to the in-person meeting, how much, you said you spent about an hour going over the agreement. Was that on the phone, person, or at both times?
Both times. So on the phone, it typically takes about an hour, and I can't speak to Mr. Orel in the specific time that it took for him. But typically it takes about an hour. We review it over the phone. I have a copy in front of me and I go over it with them. They're not provided a copy at that time. They are provided a copy when they come in to sign it, and we go over it in full again.
So basically 2 hours. You would ask.
It was an hour each time, typically about an hour each time.
Thank you.
Any further questions from the board panel? Ms. Loper, I believe you testified that Mr. Orel exited the room to speak to
An attempt to call a union rep.
okay. Do you know, was that union rep an attorney?
I don't know. He just asked to call someone, and so that was definitely permitted.
Can you redirect, Ms. May?
No,
Do you have another witness?
the state will rest.
Thank you. Mr. Orel, you may present your case.
Apologies if I'm not doing this right. I'm not an attorney. And I wrote up my case in chief, and we'll go over a few things. I was depressed about my situation at work. Exhibits D1 through D12, my exhibits will show that with Dr. Datz's evaluation of me when I went to see her in Hattiesburg. I used improper, even poor choices to cope with depression. And I admitted that. And I sought help from a therapist when I could no longer handle it on my own. And her name's Dr. Mestrone. I guess I'm calling myself as a witness here, so bear with me. Other coping mechanisms were proposed as soon as I started working out with my personal trainer 3 times a week. I soon suffered an incarcerated hernia, which required urgent surgery. Soon after returning to work, I developed a DVT. Needless to say, workouts were halted for a few months as I healed and my depression worsened. Continued to see my therapist, drinking with occasional marijuana use. And my work life was horrible. The hostile environment didn't make the depression any better. I was selected for random drug testing on January 21st of 2020. I contacted the Employee Assistance Program Director the next day because I knew what the results would be. Soon after, I reported to the Florida and Louisiana Boards of Nursing, states that at the time I held active license in. After not hearing back from either board, I attempted contact with the Louisiana board and was told to report to the Mississippi Board of Nursing because that's where the incident occurred in the state at the VA. After no replies to my emails, I contacted the Mississippi Board Compliance Department. I spoke with Ms. Verna Davis and about the self-report. She wasn't sure why no one had contacted me, but asked in her email to see my drug screen report, and I sent her that. She also recommended the MAP section of the board's websites, where I found 3 self-study courses and took them all. That's Exhibit C 01 to 03. The MAP also listed preferred professional testing sites for psychological evaluations, and this was part of the EAP protocol. So I chose one from the list, hoping that this might help with my reinstatement at the VA. And that was Dr. Datz up in Hattiesburg, down in Hattiesburg. I did the testing and evaluation, but was terminated before the results were even sent to the VA, EAP director. Although I remained abstinent from marijuana, my drinking continued to the point that I knew I needed help. I checked into Pine Grove Behavioral Health at the recommendation of my therapist, Dr. Mistrone, on November 2nd, 2020. While there, I completed a professional recovery tract as well as gained insight into my behaviors and poor coping skills, Exhibits E001. And a few days after leaving the program, I met with Casey Loper with the MNVP and signed the contract, read everything, signed it. It took us an hour to go over everything and read everything. And yes, I did ask that because I was entering voluntarily, how easy would it be to get out of the program? And she referred me to Section J. That's A06, page 6 of the contract, which didn't mention that this was a violation of nurse practice laws. And that was the reason I signed it, because I didn't see that a potential violation was there to exist. So I signed the contract. Referring now to Exhibit B01, which are emails, which we just went through to some extent. When I asked her what would happen if I left the program, she said that if you chose to terminate your contract, we send the information to legal and they determine if there will be further action or not. So not saying that this was a violation, a complete violation of nurse practice laws, I said, okay, let's keep thinking on this same method of thinking, that it's okay to get out because they'll turn it over to the board. I've already been investigated by the board prior to entering the program, and that turned out nothing. And so I assumed that the board wouldn't have an issue with me leaving the program because the previous investigation proved nothing found, to deter me from getting in the program. On 5/21, I emailed Ms. Loper my request to drop out, and that's B002. She replied that day with instructions and the first reference to Mississippi Admin Code 2826, Rule 1.12A, that covers termination. And B004. So over the weekend, the weekend went by, and then on Monday or Tuesday, whichever day the 24th was, I sent a notarized request with intent to drop out of the program. And that was B003, as previously brought up. On the very next day, I emailed Ms. Loper that I was having second thoughts about getting out of the program. And meeting with my therapist, I didn't want to get out of the program. Basically, that was how I stated it in the email, but I was hoping that we could put the brakes on this whole exit strategy and just pretend it never happened and stay in the program. And so that was exhibit B05 when I asked if we could, that I was having second thoughts. Could we talk about just modifying the narcotic access and distribution at work? Because I'm interviewing for a job tomorrow and would like to be able to tell them that they won't have to babysit me if that's doable. And she replied that day, stating that she would have to review everything with her team in the case review. Since we've already had your case review today, see if that would even be possible to revoke the letter that was sent. If it is possible, you would have to go through the request for modification processes. And I'm assuming that was a modification for narcotic distribution. Okay. The next communication I received from Ms. Loper was the state's exhibit B7, which was a notice of termination from the program. Since leaving the program, I've continued with my recovery. I see a psychiatric nurse practitioner, Ms. Beverly Ells, for my meds and my aftercare. I also do urinary drug testing every appointment, and all of which have been negative. And that's exhibit F002. I continue to see my therapist monthly, Dr. Mastrone. I've been actively working the steps with my AA sponsor, Mr. Al Warsh, and attend at least 3 meetings a week. And can I call him as a witness at this point in time?
If you're ready to, sir.
Okay. I'd like to call Mr. Al Warsh, who's on Zoom. Hey, Al, can you hear me?
Yeah, you want me to just talk or you want to ask questions?
I was just going to ask you a question. What do you think about how has my recovery been as far as you're concerned, and my working the steps with you since we started back in January of 21?
I haven't had anybody in 15 years watching people in the Alabama Nurse Practitioner Act, and also running the central office that was as willing. Typically, the nurses come in and they're very hostile for the first year or two.
We're having a little trouble understanding. I'm
okay, sure. I'm sorry. In the 15 years I've seen nurses in the Alabama Nurse Practitioner Act, he has got the most willingness I've ever seen. Typically, nurses come in with a a chip on their shoulder for about the first 2 years. And then they realize, hey, wait a minute, there's some reason for me to be here, and this is to my benefit. And I saw none of that hesitancy in him. He got a sponsor fairly immediately. He showed up, we were twice a week until we got to the 4th step. And then we went back to 1 day a week. He immediately took on the responsibility of running the meeting on every Monday, and he's been quite reliable on that. So I've been very impressed. Haven't had a sponsee that was as diligent as he has been.
Exhibits G1 through G5, you'll see character references from several colleagues, mostly from the VA. And
Ms. May, at this time, do you have questions for Mr. Orel, Mr. Wright, and Gabby?
Yes. Okay, Mr. Orel, hi. Good morning.
good morning.
I want to first ask you, or actually ask you to go to the agreement as Exhibit B9.
Okay.
Signed this agreement December 15, 2020. Is that correct?
That is correct.
Okay. And I want to specifically go to page 8, subsection Q. And are those your initials that appear where it says initials after paragraph Q?
Yes, they are.
Okay. And would you agree with me that paragraph Q talks about completion with all terms and conditions of the program as specified in part 28, 26 of the Mississippi Administrative Code and the MNVP agreement? Would you agree with that's what it says?
Yes, I agree. That's what it says.
Okay. You testified earlier that you did not realize it was a violation of the Nurse Practice Act, but it clearly states in subsection Q that you must complete to be in the program the conditions as specified in part 28, 26. Would you agree with me?
I agree.
Okay. You testified earlier that you had gone to see Mr. Is it Miss Gatz or Mr. Gatz?
Miss.
Miss, okay. And that was in March of 2020, agreed?
Agreed.
Okay. I'm curious, on page 4 of 12 of that agreement, and Mr. Orel, I'm specifically looking at paragraph 2 on page 4 of 12. Just let me know, take your time, just let me know when you're there.
Okay, I got it.
Okay. You testified earlier and admitted to the board that you had a positive short test with the VA, I believe, for alcohol and for THC. Is that what I understood?
Just for THC.
Just for THC. Would that have been January 21, 2020?
Yes.
Okay. That second paragraph, the assessor states that you were thinking about being drug tested at work. And I believe it quoted you. I want to make sure we have this on the record. Would you agree with me that it quote, this assessor is saying that it was a risk that you were willing to take so that you wouldn't become a damn drunk, end of quote. Would that be an accurate statement of what you said to Ms. Gatz?
That's exactly what I said to her.
Okay. I asked that because the next sentence talks about drinking became more frequent as a method to cope with stress. And when you had the positive screen, January 21, 2020 for THC, it was after an incident where you were publicly demoted. Is that accurate?
Correct.
Okay. What was the incident?
I Our previous anesthesia section chief, before he retired, named me lead CRNA of our anesthesia department. I had been integral in getting a student anesthesia rotation there from LSU. I basically set up and built the department after we moved to a different facility. And he admired that work and made me lead anesthetist. It was all headache, no extra pay or anything, just extra headache. And but I took the job gladly. I was proud of what I'd done. And we had a turnover of management. My old chief retired, a new chief was hired, and a new surgery section chief was hired. And the VA had just changed its rules where a lead CRNA could now get a promotion for that position. And they didn't want to put me in that position. And so our chief of surgery called a meeting with the whole anesthesia department to basically tell me that there was no such thing as a lead CRNA, that it wasn't on the pay charts downstairs in HR, and that we never had a lead CRNA, and that I was definitely not the lead CRNA. And drug test came, I think, 2 days later.
Was the result of the drug test the basis for your termination with VA?
Correct.
Okay. All right. So after you received the report assessment with stats, you did go into inpatient treatment with Pine Grove. Agree? Okay. And you heard Ms. Loper's testimony, and you've seen the evidence in the report that you were discharged as having an alcohol use disorder severe, a cannabis use disorder moderate, and major depressive disorder recurrent. Would you agree?
Yes.
Okay. And that was, give or take, in December of 2020, right?
Yes.
Okay. And you signed the agreement about 4 days after that, 12/15/2020.
Correct.
Right. And you were compliant with Spectrum for roughly 5 months. Would you agree with me?
Yes.
Okay. So I guess the question that's burning inside everyone's mind is that if you had gone into treatment, received the diagnosis that is here in the evidence and your testimony, you signed the agreement with a nurse voluntary program, why in the world would you not want to continue to participate in the program? Why would you want to voluntarily leave the program?
It was an emotional decision. It wasn't with my conscious brain or my rational mind. It was my emotional mind that was making these decisions. We all have them. We're human. And I reacted out of emotion instead of rational thought. And
Do you believe you have a substance use disorder issue? No, ma'am. You do not.
I do not. Well, I had one. I don't now.
So once you were diagnosed with it, what then is your testimony as to why you don't have one anymore?
Well, I'll always be an alcoholic. I don't know if I'll drink 10 years from now, but I know I'm not going to drink today. And that's the way we do it in Alcoholics Anonymous, is one day at a time. And as far as substance abuse goes, that ruined my career. Instead of working my last 2 or 3 years at the VA, I got fired, humiliated, and I hope to recover from that mentally, emotionally one day. It still opens up wounds, and I know that I'll never go back to using drugs.
But the board doesn't know that, do they? Not with any evidence currently showing you have any negative screens. Would you agree?
I do have negative screens, and
those reports are provided as evidence today?
yes,
And what exhibit?
that was in F001.
I believe that is a letter.
It's a letter. They do self-administered drug tests in their office with a urine specimen.
And do you know the dates that you are to appear there?
Excuse me?
Do you know the dates that you are to appear to see this individual from New South?
Yeah, the appointment's made 3 weeks ahead of time.
So those aren't random screens that are provided you then?
No, ma'am, they're not random.
Okay. And we don't have the results here today as evidence on your behalf. do we?
No, ma'am.
Okay. And Mr. Orel, I want to go back to the point where when you initially requested to rescind the agreement with the MMVP program, you were putting your career over your substance use issue, weren't you not?
When I rescinded or when I requested?
Requested.
Yeah, I just wasn't thinking clearly. And,
You didn't want to tell the employer.
well, I told him already. I told him I was in a monitoring program and he said, there's going to be a problem if we have to check out narcotics for you.
So the issue wasn't disclosing the agreement to the employer. The issue was you not administering for 6 months narcotics. And you understood from Ms. Loper that that was an agreement that it's pretty consistent across the board to participate in the program.
I know it was for me. I can't speak for anybody else.
And are you currently employed?
No, ma'am.
I want to ask about some licensure issue, and forgive me, I'm jumping around, but I noted in some exhibits that actually the state did admit, and I wanted to ask questions about it. I believe it's exhibit B3 and B4 specifically. Can you talk about the license you have in Alabama? Is that a RN license, APRN license, or both?
I don't currently have an Alabama license.
Okay, so it is expired.
It has expired.
And when you did have a license, which license was expired? Was it a CRNA? Was it just an RN?
I had both licenses.
What about Florida?
Florida, I still am active in Florida.
With both?
Yes.
What about Louisiana?
Inactive in Louisiana, but I had both.
And Texas?
Texas, I only had briefly when I was doing a lot of locum tenens, and it's been expired for many years.
So Florida and Mississippi then would be the states where you're currently licensed.
Correct.
Okay. Thank you for clarifying that. I have a question about medications, Mr. Orel. Wrong exhibit. 1 second. B13. B13, if you'll look with me, I know there's lots of exhibits here.
Got it.
Would you agree with me that this is the Mississippi pharmacy profile printout for you?
I wasn't sure quite what this was.
Sure. But can you agree with me that there are no medications listed here?
Can agree with that.
All right. And I asked about your licensure and where you live, is so that I'm wondering then, if you're not taking or fulfilling prescriptions in Mississippi, are you currently on any medications and getting those filled in Alabama?
Yes, ma'am. I live in Mobile.
Okay. And what medications are you currently taking?
Taking Effexor. Okay. Omeprazole. And Buspar.
And did you supply the MMVP program with those prescriptions?
Yes, ma'am.
And that would have been pursuant to the agreement that you signed, right?
The Effexor was probably changed because that was, I was on Prozac before that, and I believe I was out of the program before when we changed to Effexor.
You need to remind me, Mr. Orel, I wrote it down, but I can't remember the exact date. In your earlier testimony, I think you said the last time you had a sip of alcohol was October of 2020, but I can't recall the date.
October 11th.
October 11th. And when is the last date that you had THC or any part of any component of marijuana or cannabis?
That would be before January 21st, probably January 18th, 19th, somewhere in there.
And we're talking about the year of 2020?
Yes, ma'am.
Okay. So then if I were to ask you the date of your sobriety, what date would you provide me?
October 11th.
And you do have a sponsor, as evidenced by your witness today, right?
Yes, ma'am.
How long has he been your sponsor?
I believe he started, it was my temporary sponsor as soon as I was required to name one for the program. And he's been my sponsor ever since. That was, I would say, since January of 21.
And do you attend AANA meetings?
AA meetings? Yes, ma'am.
And where?
I attend some of them via Zoom. I attend some of them at the Alano Club and some of them at the it's a place I checked in before. It was on Hillcrest Road.
Okay. How often do you attend these meetings?
Now I'm currently going 3 to 4 meetings a week.
I'm sorry, 3 or
3
4
to 4
a week?
a week.
And how would you describe your support system?
I would say it's very good.
Who's involved in that?
My wife, my kids, my parents, my sponsor, the people in my home AA group.
But you don't think you have a problem?
You know, I'll admit I have a substance abuse problem with alcohol. I admit, though, that I've also admit that I've been sober since October 11th of 2020. And one of the things they taught us at Pine Grove was that you'll always be an addict. You'll always be an alcoholic. And to deny that is denying it, you know, is just cheating yourself. Just tell yourself you're always going to be one. And live with it and fight hard and work hard to not use anymore.
Exhibit B12, Ms. Orel, the last page. There.
Is that page 12 of 12?
Yes.
Yes, ma'am.
Wait, actually, it would be page 9 at the bottom. Exhibit B12, and at the bottom it says page 9.
Is this from Forest General, Forest
Yes.
Health? Okay,
Yes.
I'm on that page.
Did you read this return to work recommendation?
Yes, ma'am.
Okay. And this was about 4 days prior to you signing the agreement with MMVP. Would you agree with me?
Yes, ma'am.
All right. And in number 1, they recommended, this is Pine Grove, they recommended that you sign a 5-year monitoring agreement. Would you agree with me?
I did that.
Right. Because it asked that you have random drug and alcohol screens.
And I did that
Okay. For 5 months.
for 5 months.
That you indulge in meetings and therapy attendance. Correct?
Correct.
Okay. And then it also says other recovery efforts, which I understand you are doing through New South Psychiatry, right?
Correct.
Who mandates that you do that? Who monitors that you do that?
I do.
In number 2, Pine Grove also recommended some specifics that you heard Ms. Loper testify to about what would be a safe and appropriate work recommendation so that you could balance working on your recovery and work as a nurse. Would you agree with me there?
State that again, where?
So in paragraph 2, Pine Grove did recommend some of these work terms about how best you could perform as a nurse in a safe situation.
That's correct. Yes, ma'am.
Okay, all right. And again, who is to monitor this?
The MNVP.
But are they now?
No.
Okay. All right. So at the end of the day, Mr. Orel, why should the board entertain the possibility of you continuing as a nurse with your blatant noncompliance with a voluntary alternative discipline program?
Well, because I know I made the wrong decision by asking to get out of the program. And I asked to get back in it, and it was too late. I'm tested for substances every 3 weeks. I do my AA meetings. I'm working with my sponsor. My recovery. And, you know, I don't know what else to tell you.
Should the board allow you the chance through the compliance program here at the board, would you be willing to do whatever the board asked you to do?
Yes, I'm at the mercy of the board, and I would do whatever the board required me to do.
If they asked you to pay a fine?
Yes, ma'am, I'm willing to do anything to get back to practicing what I love doing the most.
If they asked you to submit to some education?
Yes, ma'am, I'm willing to do anything.
If they put you on probation for a period of months or years?
Yes, ma'am.
Drug testing?
Yes, ma'am.
AA meetings?
Yes, ma'am.
Confined your practice to the state of Mississippi while you practice as a nurse?
That's kind of hard because of the job situation, the job market. The closest job I could find in Mississippi was an hour and 20 minutes away from my home. And one of the hospital, I live 10 minutes from a hospital in Mobile, and they have some openings. And that was one of the things that one of the things that I just found out about recently, that I had hoped after this was all over, that I'd hoped that I could end up working 10 minutes from home, and with the agreement in place, or some type of agreement in place, so that I could finish out my career there.
You may not be aware of this, the compliance program here may be a little more strict than MMVP.
Okay.
And you currently do not have an Alabama license, is what I heard you testify to, correct?
That's correct.
So you would be at the mercy of the Mississippi, under your Mississippi license to work.
Until that case, if the Alabama granted me a license, or gave me a license.
No further questions.
Any questions from the board panel? Mr. Orel?
So, Mr. Orel, looking at the information you provided with us today, I noticed on your Southern Behavioral Medicine Association or Associates, the recommendation was to receive treatment weekly to biweekly. However, I'm seeing where you're getting treatment, but it's only once a month.
This recommendation was made in March of 2020, and since joining the program, joining MMVP, I was seeing my therapist every week. And from March, when Dr. Datz made these recommendations, I was seeing her about every 2 weeks. Now it's once a month.
Just to clarify, when you initially got this, where it said weekly to bi-weekly, are you saying your sobriety has improved so much, or you dealt with the issues that we have moved out to once a month? Is that correct? I do have a few other questions, just because once again, we're all sitting here and we have to protect the public ultimately at the end of the day.
Yes, ma'am.
And so, how can we be assured, that we won't see this issue come before us again, as far as your sobriety goes?
Because I take great pride in my sobriety now. I'm taking better care of my mental health. I know that it's a big part of my life now. And I'm working out 3 to 4 times a week. I'm seeing my therapist monthly. I'm seeing the psychiatric nurse practitioner every 3 weeks. I see my sponsor once a week, and I go to meetings with him 3 or 4 times a week. And I'm dedicated to my recovery.
And I believe that was going to be my next question, tying into that one. What things or programs are you utilizing for your mental health? You just said you were working out.
I'm working out. We changed medications. I'm getting more exercise. My daughter just had a baby, and they're living with us now. So I'm taking care of. I spend time helping her at nights and taking care of an infant and doing those little things. It's hard to be depressed when you got a little baby in your arms and you're feeding them and depending on you. So I take great pride in my sobriety and my mental health, and I'm getting better. And
the last question I have for you before I let Dr. Stewart step in, the only other thing I just have a question about is, would you be able to provide the documentation of your AA and A meetings for us?
I don't know that the Zoom provides a documentation that when you go into Zoom every time. But I've got people that would testify that I've been there. Mr. Warsh, for one, is there almost like clockwork. But I turned in reports to the MNVP when I was going. We had to do 90 meetings in 90 days. When I got out, I think I did 125 meetings in 90 days, and or something to that effect. It may not be that same number, but I did a lot of meetings the first 90 days. And just diving in full speed, head first into the AA program just to get a toehold in it, and it's hooked me. I'm sober, and I'm not a dry drunk. I'm happy sober, and
Well, the reason I ask this is I know that if we make the decision to allow you to continue practicing, that is one of the things that is required is documentation of your meetings. And even if it's in a calendar form that shows where your sponsor has seen you.
right. And most in-person meetings, you can give them a piece of paper and they'll sign it that you were there, and you kind of hold on to it for a month or whenever you're due to turn it back in, and and then just that's the way I did it when I first started, when we were doing paper.
That's all.
Well, Mr. Orwell, thank you for coming and being forthcoming and honest and about your struggles and how you're managing. And I appreciate you having our witness here. I have 3 or 4 questions, and it's going to seem like I'm jumping around. It's just kind of trying to get clarification. So when you stepped out of the meeting with Ms. Loper to call a union rep, can you tell us about that, who that was?
The union president at the VA, he's not an attorney. He just happens to be a union president. And no, I couldn't reach him by phone, so I called my wife and spoke to my wife.
So the union president is the union for all VA healthcare workers? Is this a union
Local union at the VA in Biloxi.
for all employees at the VA, regardless? It's not related to anesthetists per se. Okay. Did you ever speak with that person?
No, I did not.
Okay, so Now, the other question that I have, the 5 months that you were under spectrum surveillance, you missed a screen.
Yeah, that was, I think it was New Year's Day, the 2 weeks after I'd been in the program, and we had a lot going on that day, and I just completely forgot all about it. It was a check-in. It wasn't a screen. It wasn't a drug screen. It was just a check-in. Yes, ma'am.
So you failed to check in around New Year's Day.
Yeah.
Okay, now what type of work is it that you really want to do? I mean, I know you're CRNA. That's a high risk area.
Yes, ma'am, it is.
So
But-
where is it that you want to work?
Like to return back to Providence Hospital in Mobile, which is less than 10 minutes from my home. I've spent most of my career working in Mississippi on the coast, and would gladly go back again if there were some job openings, but most of those jobs have been taken, and there are no openings there. The only opening that I know of is at Memorial Hospital in Gulfport, which if I have to go there, I'll go there. It's just an hour and 15 some odd minutes from home.
So what area of nursing do you want to practice?
Anesthesia, ma'am. I'm gifted at it, and
Right.
it's something I take great pride in doing. I've spent 32 years doing it, and although the last 2 years have been on the sideline, I've spent a lot of time doing it, and take great pride in the quality of care I give my patients.
Right, and so the OR, the PACU, high-risk areas. So are there other areas that you would be interested in working as a nurse?
No, ma'am, I couldn't see that.
Okay, all right, so, the last question I have is, you said you have extra baby in the home. Do you have, this is not related to the baby, but do you have anyone in the home that drinks alcohol? Do you have any alcohol in your home? I think that's it. Thank you. I really appreciate you being here.
Anything further from the board panel from Mr. Orel? Any follow-up from Mr. Orel?
Follow up.
Do you have any questions for Mr. Walsh? Do any member of the board panel have any questions for Mr. Walsh? Okay. Are we ready for closing?
Yes.
All right. You may proceed.
I think what we have before the panel today, honestly, is Mr. Orel wanting to take his sobriety into his own hands. He went and saw the stats, understood the parameters, understood and admitted there was an issue there, was sort of afraid even about him becoming a damn drunk, as was quoted in the report. And so then that ultimately led to him being in inpatient treatment in Pine Grove. When he was in Pine Grove, he did complete a month of inpatient treatment. He came out of Pine Grove with a diagnosis of alcohol use disorder, severe. He also came out with some THC cannabis diagnosis, moderate. 4 days after that time, he signed the agreement with MMVP. And during the course of that time, maybe even a little bit prior before, he had conversations with Ms. Loper. He was given materials about the voluntary program. Discussion was had. It was an hour testified to by Ms. Loper, explaining the program, explaining the conditions, explaining what this program was. Mr. Orel came to this board physical office on December 15, 2020. He signed the agreement. Maybe at first had a question or two, admittedly stepped out, as you heard him testify to, but came back. And not only did he sign the agreement, he initialed every single paragraph in that agreement. The 2 paragraphs that seemed to have given him heartburn were the fact that he had disclosed the agreement to future employers and the fact that he couldn't access narcotics within 6 months. Ms. Loper testified that she explained those conditions to him. Mr. Orel, again, voluntarily signed that agreement. This is a program that requires voluntary participation. There should be some concern from the board when there was a little bit of inconsistent testimony from Mr. Orel about whether or not he thought he had a problem. Now, we have 5 months of drug screens, and that's it. We have a letter from a therapist that he is seeing continually, which that is good. But those aren't random screens. Those aren't monitored. In fact, even Pine Grove recommended he enter into the program. And not only that he enter into the program, but that he adhere to certain recommendations when entering the workforce. Mr. Orel said he understood that. Yet, who's going to monitor that? The state would just submit today that it has met its burden to prove clearly and convincingly that he did violate the Nurse Practice Act, specifically the MMVP Nurse Code, Part 2826. He did not complete the agreement. He admits he did not complete the agreement. So then the question becomes, what does the panel do with that? If the panel is convinced that Mr. Orel indeed deserves another chance, the state would just ask that it certainly have protections of the public in mind by placing certain conditions on his license so that, again, he can be properly monitored and properly assured that the public, again, can be safe. That's all.
Mr. Orel?
Getting out of the MNVP was a very hard decision for me. I struggled over it for several days. I've been out of work so long that I desperately wanted to rejoin the workforce, and I was afraid that it would somehow stand in my way. I would have probably already been back to work by now had I not gotten out. I've been a CRNA for 32 years. I take great pride in that. I'm not, however, proud of how I let my mental health get in the way of making the right decisions about how I deal with stress. As an adjunct faculty for LSU School of Nurse Anesthesiology, I really enjoyed teaching students new and old techniques for their anesthesia careers. I felt like I let them down. I let the veterans down, who I love dearly. I only have a few more years to work before I retire, and would like to enjoy those years doing what I've always done best, providing high quality, safe anesthesia for my patients. I have since learned that my mental health is a very important part of a healthy lifestyle, and I take it seriously. I've been dedicated to my recovery and will continue to be steadfast, whether in MNVP or not. But I'm asking you here today to let me return to the program, let me work so that I can put this stamp on my career and go out on top. Thank you.
Thank you.
I thank you both for your presentations this morning, leading into this afternoon. But this time I'll entertain a motion for the panel to enter a closed determination to ascertain whether executive session is necessary regarding this matter.
I move that the panel go into closed determination to assess the need for executive session to consider Mr. Orel's case.
I will second that.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. Now entertain a motion for the board to enter to executive session for deliberation on this matter.
I move that the panel go into executive session to deliberate the case before us, Mr. Christopher Orel.
I will second that.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Opposed? Motion carries. The board panel will now exit to executive session. We will return at 1:20.
What time, sir?
120. We might need to let them
Mr. Walsh, if you want to turn your camera off, you may. The board will return at 1:20 PM.
Thank you.
Thank you. Hi, Brittany. Yes, you can return back at 1:20 as well. You can stay on or you can log back in.
All right, thank you everyone for your patience. We are back on the record. At this time, I will entertain a motion for the board to return to regular session.
Move that the board return to regular session.
It's been moved and properly seconded. All in favor, please signify by saying aye. Any opposed? Motion carries unanimously. The board panel is now back in regular session. Following deliberation on license number R 726-591 and R 901-634 CRNA, the board panel renders the following: $1,000 fine. CRNA privileges suspended for a minimum of 48 months. Following that, a petition for reinstatement may be heard. 60 months probation, license restricted. There will be prohibited areas of practice in addition to the return to work recommendations from Pine Grove. A copy of this order will be forwarded to the licensee within 4 to 6 weeks. Barring any questions, you are excused.
Thank you.
Dillworth? Who's her? Britney? She's still on. Ms. Dillworth?
Sorry, I'm trying to unmute it. I was trying
Okay,
to. Can you hear me?
I can hear you. I can't see you.
I'm starting the video.
Oh, there you are. Yes.
Okay, how are you?
I apologize. We're running a little bit behind, but I'm glad that you're on today. We are ready to proceed with your case, and I was just making sure that you were ready.
Yes, ma'am.
Your witness looks like is online as well. Leah Morrison.
Yes, ma'am.
Okay. I have Denise Morrison here. Does she go by Leah or Denise?
Is she on me? Either or. That's her.
Can you hear me?
Yes, I can.
I answer by both. So whichever one you use, I'll answer you.
You tell us.
Hey, how are you?
Hi. You tell us which name you prefer. It might be easier that way.
You can just call me Denise.
Okay, Denise.
Okay. Mhm.
All right, good afternoon, everyone. My name is Edward Wiggins. I will be serving as the hearing officer. The next matter before the board panel is P 329752. Is the licensee present?
Yes.
All right, please state your name.
My full name is Britney Kayate Dillworth.
All right, thank you. At this time, I'll ask that all witnesses be sworn in. Does the state have any witnesses?
No, the state does not have witnesses. It'll be Miss Britney Dillworth and Denise Morrison.
Ms. Morrison and Ms. Dillworth, will you please raise your right hand so I can swear you in? Each and every one of you solemnly swear or affirm that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Morrison? You're muted.
Okay.
Did you hear the oath?
I can't hear you.
Okay, I'm going to administer the oath to you. You solemnly swear that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mhm.
Thank you very much. We will begin with opening statements. Then we will have the case from the state. The licensee will have an opportunity to respond. There will be an opportunity for questions to be asked of the witnesses as well as cross-examination and any redirect if needed. Members of the board panel as well as myself will be also able to ask questions. At the conclusion of presentation of both sides, we will have closing statements. The board will then make findings of fact and conclusions of law and render its decision, a copy of which will be sent to the licensee within 4 to 6 weeks of this hearing. For the record, there is a quorum present. These hearings are open to the public. Council, do we have any preliminary matters?
We do. I do need to make a motion at this time to admit exhibits into the record. The state would move that B1 through B10 be admitted into evidence.
Ms. Dillworth, do you have any objection?
I don't.
Ms. Dillworth, are you represented by counsel?
I'm not.
You understand you have the right to be represented by counsel?
I do.
You also understand you have the right to present witnesses on your behalf?
Yes.
Also that you have the right to have subpoenas issued by this board on your behalf?
Yes.
And you are ready to proceed with this hearing today?
Yes, sir.
All right, thank you very much.
Respondent, Ms. Dillworth, has also submitted 2 items of evidence that she would like admitted into the record, R1 and R2.
State has no objection. They're admitted.
Lastly, as a preliminary matter, my understanding after conferring with Ms. Dillworth is that Ms. Dillworth will plead guilty today to the charges as outlined in the complaint as marked within Exhibit B5.
Ms. Dillworth, did you hear and understand Ms. May's statement?
I did. I talked to Mr. Brett yesterday, and that's what I had emailed him.
So it is your intention today to plead guilty to these charges?
Yes, sir.
Thank you. Ms. May?
As a brief opening statement, we are here today on behalf of the state instituting formal charges against the license of Britney Dillworth, license number P329752. The state will allege, as Ms. Dillworth has just entered a plea of guilt, that the violation of the Nurse Practice Act occurred 73-15-29-1 subsection K, in that Ms. Dillworth did engage in conduct likely to deceive, defraud, or harm the public. The testimony and evidence will show that Ms. Dillworth, in applying for employment as a nurse with the Mississippi State Veterans Home in Oxford, Mississippi, did submit to a pre-employment drug screen on about October 21, 2020. The drug screen result was positive for cocaine. Ms. Dillworth, in her statement to the board, as the evidence will reveal and show, on December 9, 2020, Ms. Dillworth did assert that she did not use drugs, but the positive screen was a result of submission, fraudulent submission of a relative's urine specimen, and passed it as her own. The evidence and testimony will show that indeed a violation occurred, and the board panel should find at the conclusion of this hearing that Ms. Dillworth did indeed violate the Nurse Practice Act.
Thank you, Ms. May. Ms. Dillworth, do you want to address the board at this time?
Yes, sir. Well, with that too, well, I didn't know how to. I did have another piece of evidence that the Veterans Home called me actually this summer asking me if I wanted to come work. I don't know if it was a miscommunication or whatnot, but I had that voicemail that they were asking if I wanted to come for a job interview. But I don't know if this is, I don't know. Well, the exhibit that I had put into play was I took a drug screen in which everything was negative. I have a signed affidavit, also notarized affidavit from that relative stating what happened. And I don't know, my witness that I have on hand, is this the time? I'm not sure. I've never done anything like this, so I'm not sure. Like, am I supposed to ask her anything, or is that another part of this?
Well, we'll just stop there for now.
Okay.
Ms. May, you can proceed.
Sure. The state at this time, given the enter of guilty plea by Ms. Dillworth, will rest on its pleadings and have the right to cross-examine Ms. Dillworth at the end of her presentation.
Ms. Dillworth, you can go ahead now.
Oh, with the witness? Okay.
ma'am.
Well, I have Dr. Denise Morrison. And the reason I wanted to have her as a witness was not only because she's my faith-based leader, but also she is a previous employer, and just for her to give a little background as far as me as a person and my nature of work ethic and everything. So that's the reason that I have her on this Zoom meeting.
Okay, so did you have questions for her, or do you just want her to make a statement?
Just want her to make a statement. I don't have any questions.
Okay, is she ready to proceed?
I am ready.
Okay, you have the floor.
Okay, first I'd like to say good afternoon to everyone. I am really totally shocked that I'm even having to witness Brittany's character. Brittany is a hard worker. Brittany has always been involved in the community, has always had a love for people and for children. Brittany, her character, hardworking, on-time worker, gives it her all worker. So again, I'm totally shocked that I'm here doing this. But Brittany gives her all in all that she does. She has been a star athlete in her days. She's well known throughout the small town of Pontotoc. A student, again. Brittany's character has never been in question, to my knowledge, ever before. And again, I speak highly of her because I know her as a person, and I very value her as a person and for her character. So that's pretty much what I have to say. She's strong in the community, strong in the church. She's a great volunteer. She's done numerous things throughout the community for nonprofits. So I can only speak highly of her as the person that I know her to be. And I've never known her to do any substance abuse or even drinking or anything. I've never known or ever heard of anything. And again, it's a small town, but never heard anything. And in her character, again, I've never witnessed her even exhibiting any of those characteristics ever at all.
All right, thank you, Ms. Morrison.
You're very welcome.
Ms. Dillworth, did you have anything you wanted to add?
No, sir.
Ms. May, do you have any questions?
I do. Good afternoon, Ms. Dillworth.
Hi.
You can hear me okay?
Yes. Mm-hmm.
All right. So you have before you the exhibits that I had emailed you previously?
Yes, ma'am.
Okay, good. I wanted to make sure that before the record, you could testify that you did receive all exhibits in your matter today, B1 through B10, correct?
I did. I printed them all.
Okay. And for the record, can you also affirm your mailing address?
So it's not the 73 Osage Lane. It's actually 161 North Martin Luther King Drive, and that's still in Pontotoc.
Okay. Have you gone to your gateway and updated your address?
I haven't.
Okay.
I just usually just put that out. Well, I wasn't thinking about doing that because I always just do it through the USPS, and it usually just, but I see that that's why I never received that that certified mail, is because it was going to the old address.
Were you aware that not updating the board with your address could be an additional violation of the Nurse Practice Act?
No, I did not know that.
Because you were correct, B5 does reflect the address, 73 Osage Lane.
Mm-hmm.
And I believe if you looked at B2, Ms. Dillworth, and that was a printout back in July of 2021, it also has 73 Osage Lane. Would you agree with me?
Yes, and that, I guess that's when I renewed, wait, when was that? 20. Yeah, I see it though. I see the 73 Osage Lane.
Okay. How long have you been at 161 North Martin Luther King Drive?
I just moved back here in the summer or this summer, so it would have been July 1st of this year. And that's why I said I didn't know that I had to change it on the gateway, because usually I would get mail once I did the USPS change of address or something, it would still come to me. So that's why I did not know that I had to do that on gateway.
Did you forward your address to any other entity, like a billing address for you to have electricity or cable?
Well, with the cable, yes, and with utilities, you have to go physically up there to get the address change. But this is the address that initially, even when I started nursing school and got my nursing license, this was my initial address. I had just moved from here to that place, and I moved back here.
And then Exhibit B10, Ms. Dillworth, is the actual proof of publication where we
it was in
board put a legal notice into the Pontotoc Progress. Is that how you ultimately found out about the hearing?
Yes, ma'am. And it was actually not even me. I have an uncle that looks at the newspaper and looks at everything, and that's how my name. Yeah, I didn't even know it was in there.
Okay. So you would agree with me then that probably a very important order of business at the conclusion of this hearing would be to update your gateway?
Yes, ma'am.
Okay, all right. All right, Ms. Dillworth, you did plead guilty to the charges that are outlined in Exhibit B5. Would you agree with me?
I did. Yes, ma'am. And
Okay.
I was advised to do that.
And you provided a statement, which is in Exhibit B8. Did you not?
I'm flipping through. I did, and that was to Mr. James.
Right. Yes, that was the investigator that you corresponded with. Is that correct?
Yes, ma'am.
And you were seeking employment with the Veterans Home.
Yes, ma'am.
Around October 21, 2020. Is that right?
Yes, ma'am.
Okay. And you had to submit to a pre-employment screen, correct?
Yes, ma'am.
Okay. But you did not use your own urine as the specimen. Is that correct?
Yes, ma'am. Because when I went for the interview, or I didn't even think it was going to be an interview, I went to put an application in. Once I put the application in, I interviewed, they hired me on the spot. Can you go take a drug screen? Okay, I was on, which I don't know, it's too much information, but I was on my cycle. And I know that with being on a cycle, your drug screen can come back inconclusive. Me needing a job, and of course, yes, I did do the wrong thing in asking for someone's urine and not just being upfront with them, but also me thinking ahead is just like, okay, if I'm telling them I can't do it right now, it might have been me not getting a job. And so ultimately that's where the mistake was I should have just been upfront with that employer about what was going on with my situation, in which that's what I explained to in Exhibit B8, what was going on, just being as honest as I can.
So you were willing to misrepresent your own urine to get the job?
In a sense.
Well, let's look at something. Let's look at Exhibit B6.
Okay.
B6 is your specimen result certificate of the drug screen. Would you agree with me?
I would.
Okay. And on the donor name, whose name does it state there?
It states mine, Britney
Okay.
Dillworth.
Okay. And it states the date of the test. Is that correct?
It was 10/21/2020.
Okay. And the collection site was at BMHCC in North Mississippi?
Yeah, had to go to Baptist Memorial.
And did you sign anything stating that that specimen that you were submitting to be tested was your specimen?
Yes, initial. So basically sign. I put my initials.
Okay, so you knowingly submitted a specimen that was not your specimen to be tested for a pre-employment drug screen.
Correct.
And you're stating to the board that your reason for doing so was that you were on your cycle.
Yes, ma'am. Sorry.
Okay. And I guess the begging question is, Ms. Dillworth, what would you have been positive for on that day if it had been your own urine?
It would have been positive for nothing other than being inconclusive from having blood in the urine. And that's from me even having given drug screens before. If someone is on their cycle, I would ask them to come back. And so that's like, I don't argue that the mistake was made by trying to use her urine or anything. Like, I'm being as upfront as I can about that.
Sure. And forgive me, but I think there might be an interesting interpretation of this because you're calling it a mistake. And could it not also be characterized as fraud?
Sorry, I heard fraud, but I didn't hear what you said.
What I was saying is, I hear what you're saying, but you're stating it was a mistake, but couldn't it also be characterized as fraud?
Well, the fraud is using someone else's urine. Yes, ma'am.
Okay. And so perhaps you didn't think it through, but to defend what you're saying as an inconclusive result, you could have defended that because it would have been your own urine, correct?
Yeah.
But when you have someone else's urine that tests positive for cocaine, here you are defending that, right?
Right. Defending that, and I'm defending myself. Yeah.
So I guess you'd agree with me then that what you're saying to the board is, I don't do drugs, right?
Correct.
But do you understand the board's still concerned with
the fraud part? Yes, ma'am. I totally get that. I do with the fraud part.
Okay. So then you are putting in their hands a situation where you pled guilty, you're acknowledging the fraud. You're at their mercy today. What should the panel do?
What should the board do?
Yeah.
Well, that's kind of, I guess, the statement that I sent you yesterday, in which I don't know if I need to say that now or wait for closing remarks. I'm not sure. But I mean, I can read it now. I'm going to read it now, I guess. So that's when I sent you yesterday. I intended to plead guilty to the charges stated. I recognize that the law has a range of disciplinary actions, the worst of these being suspension or revocation of my license. I do take full responsibility of my actions and know the seriousness and magnitude of my mistake. I do have a clean record that I have never been in trouble on, and take pride in my name and the work that I have done as a nurse. However, as a single mother of 3 and a licensee who has never failed a drug test or been suspended for disciplinary conduct, I humbly request the board to consider other disciplinary actions, including but not limited to submit to a care counseling or treatment, or to participate in a program of education prescribed by the board as a condition for continued licensure, or to practice under the supervision of a registered nurse for a specified period of time. And I humbly yield to the consideration of this board. Now, I'm currently working as a school nurse for Holly Springs School District. That's why for exhibit R1, my drug screen is out of Marshall County, Holly Springs, because that's where I work. Every day I'm giving kids pretty much Adderall or something for ADHD. I give it to them. That's what I do. I care for kids. That's what I do. And so, yeah, I do I'm at the mercy of the board, but for me to have more pros than just this one con, I just feel like prayerfully, I'm going to be, I don't know, I'm not going to say a slap on the wrist, but this is a lesson well learned for myself. And the, I guess, procedures on what to do. And when I did that, it wasn't me just thinking clearly at that time. It was me trying to get a job because I wasn't working. And so that's pretty much all I have for that question.
As a nurse, Ms. Dillworth, would you agree with me that you interact with the public the most, right?
Yes, ma'am.
More than the doctors as a nurse, right? You're hands and feet of healthcare. Would you agree?
Yes, ma'am.
Okay. And you testified that you're a school nurse, so you are dealing with the vulnerable population as well. Is that correct?
Yes, ma'am.
Okay. And so again, the board doesn't know you. They know you on paper. Would you agree with me on that?
Yes, ma'am. Because I've never had to see the board.
That's
So, yes,
right.
ma'am.
And the paper that's been submitted before the board today shows that you defrauded your potential employer by passing off a urine sample that wasn't yours. And so if they're thinking about that and looking at the paper, how do you think that would transfer to how you would be in your nursing practice?
Well, fraud within any scope, but especially with nursing, it's something that, I mean, that it's a bad thing. There's no ifs, ands, buts about it. But I don't know. I don't know.
Yeah. And would you agree with me as a nurse? I mean, documentation is the way someone can evaluate your nursing practice. Would you agree with me with that? The
Yeah,
documentation is a way to, okay, you would?
If you don't document, you didn't do it. That's something that's learned.
Right, right. And so again, I'm sorry to go back, but I mean, it's just, it does seem a little incredulous that your defense is going to be you were on your cycle, not to submit your own urine. So when you sign your name, acknowledging someone else's urine as yours, that documentation speaks loudly, does it not?
It does, but and I wish I would have put that voicemail, that documentation might, but also this voicemail saying something too, that they were trying to hire me back as a nurse. Like, I don't know where the mishap is with that, but.
And again, you may stick to it. I'm going to ask this last time, and I shouldn't ask it anymore. You're under oath, Ms. Dillworth.
Yes,
Is
ma'am.
it your testimony under oath that you are not impaired, or that you did not have anything in your system at the time you submitted or would have submitted your specimen for that test on October 21, 2020?
My right hand to God, in which I am a firm believer in God and wouldn't lie on the Bible. I did not have anything in my system. I was thinking, I need this job. I don't need any road stops. So that's why I did the fraudulent urine. As far as with using my relative's urine, I had nothing in my system. I could take I wish I would have done a hair test. You will not find anything in my system. I've never been around the drugs, cocaine, oh my gosh, especially, or anything. I was just on my cycle that day. And I should have, like I said, I should have been more upfront with that employer and saying that and just taking it if I wouldn't have got the job or not. But
how did you transport your cousin's urine to the screen?
I didn't. She came and met me and used shoot, I'm trying to think. Put it in like a bottle or something. And it's just, it doesn't, keeping it warm. And I didn't get coached. She coached me on it because I didn't even know what to do. Had a bottle. She said, just take it in there, keep it in between your legs, do what you need to do. So
Yes.
I don't even know the method of doing it. So that's why I'm saying, like, can say, I'm saying it's a mistake on my part. The fraudulent part, I get it, because fraud is putting somebody else's something as your own when it wasn't mine. But
Nothing further.
Any questions from the board panel? Ms. Dillworth?
I do. Ms. Dillworth, this is Sandra Culpepper.
yes, ma'am.
I have a few questions for you, Ms. Dillworth.
Yes,
because
ma'am.
Do you believe by attempting to use someone else's urine, even if due to your medical condition at the time, and you sat here and told us that you have done drug screens, and myself as well have done drug screens, and performed them with someone that is on their cycle, and they will process correctly. So with that being said, were you attempting to deceive the potential employer?
At that time, to get the job, yes. Not gonna say no. Now, that's not even me. I got the job offer, contingent on the drug screening. But as you can see, did not get the job because of what the results came back as. But that's not to say I would have even taken the job, even if I would have. But that's a whole nother story. But yes, ma'am, to answer your question.
Well, in response to your answer, saying just that you attempted to deceive them, do you believe that this harms the profession of nursing based on the fact that we take an oath and the fact that we can potentially harm the public even through this type of deception?
So going for a general, yes, ma'am, that it will. But when it comes to, it's just that it's so hard when I'm thinking about self and not thinking about the whole nursing realm. But when you think about deception, that's just hard for me to think about because I wasn't deceiving me being a nurse to my patients. It was me getting the job. So I don't know. Yes, ma'am, but I get.
To clarify.
Yes, ma'am.
No, there was no patient harm. Based on the oath that we take as nurses, do you feel like it was an unethical move to deceive your employer who would put you in with the potential to cause harm to the public?
Unethical move, yes. Would I have caused harm? No, ma'am, because I don't do, but unethical move, yes.
Well, with that being said, moving past that, I did notice something else in your file that was of concern to me.
Okay.
How long have you had consistent employment as an LPN since you were 2014, right?
Yes, ma'am.
So you have always practiced as an LPN.
I have practiced as an LPN. I practiced as some other things as well. Not just in the nursing realm. I've done educational stuff as well.
But that was in regard to nursing, though, correct? You used your nursing knowledge to do that job?
No, ma'am. Not on the educational side. I was like in the education field as far as being like, I've been an academic interventionist, which has nothing to do with nursing. I've also done worked with after school program and also a summer program.
And to follow up this question, because this is of my concern.
Yes, ma'am.
We know that renewal years for LPNs are odd years. So I'm looking at your nurses report. And on your nurses report, you have two different dates where you were late renewing. One of them was 2 weeks behind. The other one was nearly 4 months behind.
Mm-hmm.
Were you practicing as an LPN during those times? If we were to request your employment history, would we find that you were working while you were not licensed?
No, you wouldn't. And that's the reason
You're
why.
telling me.
That's the reason why the late fees were there, because I didn't have the money to pay for it.
So just to clarify, are you telling me that between January 1st, 2018
Mm-hmm.
and January 12th of 18, you did not work as a nurse?
2018.
That's the first 2 weeks of January of 2018.
Yes, ma'am. I'm trying to remember what I was doing in 2018. I want to say I had just moved back from Memphis. I wouldn't have been working during those dates.
Okay, well, the other date that's of concern to me is between January 1st of 2016 and March 30th of 2016, when you renewed nearly 4 months. You did not practice at all as an LPN. Do you have a work history? Or if we asked for you to provide that?
I'm trying to think what I would have been doing. I moved to Memphis in 2015 to be a school nurse. Now, those dates that you're talking about, when did I move back? Potentially, I would have been 2016, still working for Shelby County School.
So you were practicing as a nurse at a school without a license?
Pretty That's gonna be, I'm gonna say yes, because I think I was working then.
So just to clarify, do you understand your scope of practice and how the renewal cycle works, and that you are not permitted to work without a license?
Yes, ma'am.
That's all the questions I have for you, ma'am.
Thank you.
Anything further from the board, ma'am?
I just have a question. Ms. Dillworth, I just have a very quick question. How long have you been at your current employment?
I just started in August of this year.
Okay, did you report to your employer this issue that you have that you're before the board today?
No.
All right, thank you.
Ms. Dillworth, I'm sorry. I meant to ask you one other question, because on that same nurse's report, I did see that it appears as if you had a license in Florida.
Because I was
it says on there that it was null and void. What was that about?
Because I was thinking about moving to Florida, but it turned out that I didn't. That's why I was going ahead and trying to get my Florida license, because I know it's not a compact state. And so at that time, things changed and I stayed here in Mississippi. So I never used it.
So you're telling me that you did have a license in Florida, but that it lapsed?
That I had paid all my fees and everything, yes, ma'am. And I did not pay it again because I didn't move down there and practice. I was being proactive and not reactive, I guess, at that time.
That's all I had. Yes, that's another question. I'm sorry, Ms. Dillworth. Seeing that you just told us that you were practicing in Tennessee as a school nurse, did you have a Tennessee license?
I didn't, because it was a compact state. Or it's a compact state and they didn't require me to get a Tennessee license.
When did your employment there in Tennessee end?
I came back home in 2017.
Okay, thank you, ma'am.
Welcome.
Any further questions for Ms. Dillworth? Were there any questions for Ms. Morris? Anything further, council?
I don't think so.
Ready to close? We'll begin with closing statement. Council.
It should be clear and convincing based on the evidence and testimony provided again today that Ms. Dillworth did indeed violate the Nurse Practice Act. Specifically, she defrauded the public when she did it. and did actually submit, not hers, but a relative's urine specimen, passed it for her own when trying to apply and receive employment from Mississippi Veterans Home in Oxford. She admitted and acknowledged that she signed her name, passing the fraudulent specimen off as her own. She admitted to having some premeditated communications with the relative, planning how she would defraud the drug screen. And ultimately, she doesn't try to hide the fact that she should not have done so. But the only explanation she provides is that she was on her cycle, which, when asked questions of her regarding the defensibility of that, she agreed that it would have been defensible if it came back inconclusive per her testimony, that she could have defended that. She can't defend this. So it is clear, based on the evidence of testimony, she did defraud the public. The screen speaks for itself. Her testimony, her guilty plea speaks for itself. The only question remains is what should be the fate of her license. And that should be up for this panel's decision. Your duty is to uphold and protect the public. Certainly, there should be discipline imposed against her license. As to the degree of that discipline, that will be up for this panel to decide. Thank you.
Thank you, Ms. May. Ms. Dillworth, if you have a closing statement, you can make it at this time.
I guess I read pretty much just, I'm at the leniency of the board. I'm not denying that I was in the wrong, that it was fraud, but I just know worked too hard for my license for, I guess, one con to outweigh my pros. I don't know. I know I have worked too hard for my name, and I'm just looking for leniency from the board. I can submit to drug tests, anything. That wasn't the issue. And that's me being as upfront as I can and not telling any other difference, because it could have been another way. Yes, if I would have made the right decision to just go ahead and give my specimen, this would be turned out a whole lot different. But just asking for leniency from the board, because like I said, my pros outweigh this one con, from someone that has not ever been in a court system, whether it's in a nursing realm or in the public realm. And I don't know, it's just not fun being painted like I'm a criminal when I'm not. But that's it. Thank you.
Thank you, Ms. Dillworth.
unmute.
Ms. Dillworth?
Yes, sir.
Okay, we have two other matters that should be brief. Once we conclude those, we will look at being able to deliberate on yours and theirs. So if you'll bear with us, we're trying to get through this as quickly as we can. When you're ready, counsel.
Yes. Yes, for the matter of Connie McKnight, license number R796372, I would like to call Floyd Wiley to address a preliminary matter.
You raise your right hand. Do you solemnly swear that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name for the record,
Floyd Wiley,
and in what capacity are you serving the Board of Nursing today?
as the bailiff.
And have you been able to make a determination as to whether or not Connie McKnight is present and available for her hearing today?
Yes, I have.
And what did you do to make that determination?
I went to the front of the building, called her name 5 times with no response. Went to the back of the building, called her name 5 times with no response. Checked her visitors sign-in log. She has not signed in. Checked the respondents log. She has not signed in. Checked the participant list on the Zoom call. She is not on the Zoom meeting. Virtual meeting.
I'm going to now hand you what's been marked, not yet entered into evidence, Mr. Wiley. Marked Exhibit B5. For identification purposes, can you identify marked Exhibit B5?
This is the notice of the hearing for today's hearing.
Okay, actually, it was noticed for June 17, 2021.
Yes,
Okay, originally, would you agree?
yes.
And-
Thursday, June 17th, 2021, at 8:30 a.m.
Okay, and for record purposes, can you verify that the address that's noted here on her notice, does it match the address within marked Exhibit B2 contained in our database at the Board of Nursing?
Yes, the addresses do match.
And for the record, what is that address?
It is 73 Blue Water Road, Alligator, Mississippi.
And in fact, the last page of marked Exhibit B5, Mr. Wiley, would you agree that that is a USPS tracking document that states it's unclaimed?
Yes, that is correct.
I'm going to now hand you what's been marked, not yet entered into evidence, marked Exhibit B18. Just for the record, can you identify what marked Exhibit B18 is?
It's a piece on the Bolivar bullet, proof of publication.
Okay, and can you verify to whom this notice is noticed, to whom it's being noticed in the paper?
To the respondent, yes.
Okay, and that name that appears there.
Connie McKnight.
And what day and time is Ms. McKnight ordered to appear pursuant to that legal notice?
October 6, 2021 at 8:30 a.m.
And can you verify whether or not this legal notice was published in the proof of publication, the Bolivar Bullet, 3 consecutive weeks?
Yes, it was August the 25th, 2021, September the 1st, 2021, and September the 8th, 2021.
At this time, the state would move the matter regarding Ms. McKnight be allowed to proceed, given the fact due process requirements have been met according to statutory law.
You may proceed.
At this time, the state would move that exhibits B1 through B18 be admitted into the record.
They are admitted.
And the state would now rest on its pleadings.
Thank you, counsel. That's all right.
Now we are ready to proceed with the matter regarding Linda Norton. License number R810179. The state would now call Floyd Wiley to address a preliminary matter.
Solemnly swear that the testimony you're going to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Please state your name for the record,
Lloyd Wiley,
and in what capacity do you serve the board today?
as the bailiff.
And Mr. Wiley, have you made a determination as to whether or not Linda Norton is present and available for her hearing today?
Yes, I have. I went to the front of the building, called her name 5 times with no response. To the back of the building, called her name 5 times with no response. I checked the respondent sign-in log. She has not signed in. Checked the visitor sign-in book. She has not signed in. I checked the computer to see if she was a participant on the Zoom meeting. She is not.
I'm going to hand you now, Mr. Wiley, what's been marked, not yet entered into evidence, marked Exhibit B5. For identification purposes, please state what this document is.
It is a notice of the hearing
Okay, and to whom is it noticing?
to Linda Norton
Okay, and when does this notice say that she was first to appear before the board?
on Wednesday, July 21st, 2020 at 8:30 a.m.
2020.
2021, 8:30 a.m.
And Mr. Wiley, the last page of marked Exhibit B5, can you identify what the last document is of that marked exhibit?
It is a certified letter that was returned to the board, unable to address.
And can you verify for the record whether or not the address that's contained on the notice and the return envelope, if it matches the address that's contained in the Board of Nursing database?
Yes, all 3 addresses do match.
And what is that address for the record, please?
17 Countrywood Lane, Corinth, Mississippi.
Finally, Mr. Wiley, I'm going to hand you marked Exhibit B12. For identification purposes, what is marked Exhibit B12, please?
It is a proof of publication.
And to whom is it noticing?
Linda Norton,
And Ms. Norton is summoned to appear before this board panel when?
today's date, October the 6th, 2021 at 8:30 a.m.
And this proof of publication, is it not from the Daily Corinthian, paper published in Alcorn County?
Yes, it is.
And has the legal notice been published for 3 consecutive weeks?
Yes, August the 19th, 2021, August the 26th, 2021, and September the 2nd, 2021.
At this time, the state would move the matter regarding Linda Norton be allowed to proceed, given the fact all those due process requirements have been satisfied pursuant to statutory law.
You may proceed.
At this time, the state would move exhibits B1 through B12 be admitted into the record.
They are admitted.
The state will now listen to its pleadings.
All right, thank you, counsel. Do you have any other matters to come before the board panel today?
The only matter that is before the panel is a consideration of a agreed settlement proposal involving Angela Pittman. That agreement was received yesterday. However, it was received about 2 or 3 o'clock yesterday. Counsel for Ms. Pittman had asked if the board could consider that today when it was deliberating other matters.
You have that license number handy?
Yes, no, wait, one moment.
I think we have. We have it. We
Right,
have it.
You have it? Oh, okay. Sorry, I
Thank you.
couldn't hear you. Very good. That's the only other matter before the panel today.
All right, thank you. At this time, I entertain a motion for the board to go into closed determination to assess whether executive session is necessary.
I move that the panel go into closed deliberation to discuss whether executive session is necessary.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? The motion carries unanimously. Now entertain a motion for the board to exit for deliberation on the following matters. P 329752, R 796372, R 810179, R 858398.
I move that the panel go into executive session to deliberate on the 4 cases as mentioned.
I will second that.
It's been moved and properly seconded. All in favor, please signify by saying aye. Any opposed? Motion carries unanimously. The board will now exit to executive session. And we will return shortly. All right, thank you everyone for your patience. We are back on the record. I will entertain a motion at this time for the board panel to return to regular session.
I move that the board panel return to regular session.
It has been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. The board panel is now back in regular session. Following deliberation on the matters. Is Ms. Dillworth on?
Yes, sir.
Okay, thank you. Regarding license number P 329752, the board panel renders the following: a $250 fine, chemical and psych evals, courses to include ethics, documentation, substance use disorder, to be completed within 60 days. The fine also to be paid within 60 days. The suspension is stayed. Failure to comply with the suspension. Failure to comply with these rules will cause a suspension to go in effect for a minimum of 24 months or less if the assessor recommends. Ms. Dillworth, that concludes your matter for today. You will receive a copy of the order by mail within 4 to 6 weeks. The board
Can I ask
panel.
something?
I'm sorry,
Can I ask something?
go ahead.
Like I was trying to write down everything. You said a chemical and what,
Psychological evaluation.
psychological evaluation?
Yes, ma'am.
Okay, and all this, needs to be submitted before 60 days, correct?
Right.
And those classes, are they done online or where
Yes,
would I?
ma'am.
Online?
Yes, ma'am. They're available online.
Available online. Okay, that's what, okay.
And the compliance officer will be in touch with you regarding those.
Yes, sir. Okay, thank you so much.
Okay, you're welcome. Following deliberation on the matter regarding license number R 796372, the board panel renders the following: revocation. Following deliberation on license number R 810179, the board panel renders the following: revocation. Council, is there anything before the board panel today?
That would conclude, did the board panel have the time to look at Ms. Pittman? ASB
We have reviewed those.
and the surrender as well.
Absolutely. Absent anything further, that will conclude the board panel business for today. Thank you all for your attendance.